In view of the judgment pronounced on 20th June 2024, the criminal matter is disposed of in the said terms. Yes, sir.
Pardon, madam. Tied up bail application, IA filed for interim bail. It was listed on 20th of May 2024. Lordship call for the instruction kindly taken up.
Give it.
Pardon to mention, my lord.
Yes.
Items 117 of the list.
17.
Can we 117?
120, yes.
Taken up after lunch.
Oh, it will come after lunch. If you come.
Punishment is only for 1 month.
Offense?
Offense is 323.
3?
323. Charge has not been framed. Still offense has been done.
Charge is not framed.
Not has been.
Trial is repeated.
Yes. That's
Okay,
why
people.
after lunch, my lord.
So you come before lunch also, we can do it if that's the case.
Witness.
Wait, we will do it.
Subject to my lord's.
If that is the case, if you are correct, then it has to go. Simple. Yes.
Item of 20 mile can taken up next week.
20?
Item of 20.
That's
Something
it,
like
20. 2013 matter, madam.
Message from Manoj Biar das feel in mela.
Sorry?
My senior is feel in mela.
That's right. What is this matter is about? Is it
Matter, my lord, after confirmation of appeal pending before the Sessions Court, they have filed an application under Section 391 for additional evidence that has been rejected.
already conviction?
Conviction for appeal stage.
Offense?
Offense section 37 of 37 of Pollution of Control Pollution Act, my lord. Prevention of Control of Pollution Act.
Unnecessary. Oh, keep it on Monday. Monday. It's made clear on the request of the Land Council for the petitioner. This matter is adjourned to Monday. It is made clear that no further adjournment shall be given, and the matter will be disposed of the on the urgent date. Yes.
Item number 22, my lord, may kindly be posted on Monday. Item number 22.
What is this matter?
My lord, criminal revision 26 of 2014.
I know what is this matter is about.
Order rejecting a discharge
Yeah, what we
application.
do is if the juniors are asking for adjournment, I'll not adjourn unless they tell the facts. At least they should prepare the facts.
They will be, before adjourning, they will prepare, my lord.
You must read and come. What is this case? You tell me.
The
Against what?
case has been posted to.
1 minute, sir. He has to tell. Yes.
My lord, I am not prepared, my lord.
You go and ask and come and mention. At any time you will come, I'll entertain, but read and come. At least you should know it is against what? It is against conviction or what? At least you should know. And take out the file and read it. Okay. Note kar rakhta. Yes. Which is there is none. Yes. Start. Start. 2. Yes.
Item 213 to read with 131C and 409 IPC convicted. The co-appellant has already been released by this honorable court by the CRLA.
Sentence. Sentence.
573 sentence is for 2 years
Oh, then,
on each count.
then it's all right. Admit same similar or admit realization of the realization of the fine amount.
Let it be listed along with CRLA 573.
And we granted the appeal along with
CRLA 537 of 2024.
20. Okay. Yes. Yes, tell me. Item 2.
Yes, sir.
Tell me, what do you want?
Is not permission to speak.
What do you want? You tell me. Have you read it?
Yes, sir.
What is this amount matter?
Vigilance said lordship.
Yes.
And 3 years imprisonment.
3 years.
2 years.
2 years. Okay.
And I have filed for the bail and realization fine.
What are the grounds for bail?
He's already on bail.
Huh?
He's on bail.
He's already on bail.
Yes, Your Worship.
So I'll reject that bail application. You are already bail, why the application? So I pass the order, huh? And I have tagged the matter along with the co-accused appeal. Here,
Nalla is sort of. And a free copy may kindly.
a free copy, huh? Free copy.
Hold it. Item 3.
Your Lordship, item 3 on behalf of Mr. Sarthak Naik, I'm praying for a Passover, Your Lordship.
Okay, pass over. Yes.
Item 4.
My lord, item for on behalf of Mr. M.K. Panda. Next week, my lord, I say out of the.
What is this matter is about, Milo?
My lord, say bail रे अच्छी ता अनारे कौन
Cancellation bail.
cancellation bail पे
When the bail was granted?
किसी information नहीं था मुझे किसी.
Sale. I'm passing it over, you come. Cancellation of bail, I generally, what is the offense, by the way?
Now the offense under section 341, 294, 3,
Normal 354 and 506, 307 and all. Anyway, the bail has already been granted, wrong, right, whatever.
No, bail, this only court granted, directed, leave the petition surrender before the court, and he shall be released under an appropriate term and person fixed by the court will.
Then bail is granted.
They have come here challenging that they have violated the term and condition and misused the liberty granted to them and committed a
Violated what?
other offense they are committed to other cases, my lord, after the release from bail.
I'm passing it over, ma'am, you come.
My lord, से काली की रखे जाओ कर टुडे मां मांग
Actually, appearing for the opposite party.
opposite party.
Okay, tomorrow. No problem. Yes.
Item 5.
Item 5, my lord, paper Passover, my lord, after lunch, lordship. I will.
Not
Lordship,
after
paper
lunch.
Passover.
I'm passing it over, but not after lunch.
My lord,
Very anytime.
my lord, this matter is
Lordship.
for the restoration of the case, my lord. Your lordship has directed last occasion to come with another file, my lord, and which file belongs to the section 468, 471, 420 regarding the manipulation of a date of birth certificate.
It was dismissed
It's a dispose of case, my lord.
for non-prosecution.
Yes, my lord, for non-prosecution.
Lordship, non-prosecution.
Where is that order? Where is that order
Then-
by which it was dismissed?
Order did not attach, my lord.
How will I know?
Yes.
What kind of petition is
Lordship,
this?
Lordship, I will file it in the court. Lordship, after 2 p.m. Lordship, I will reach the court. Lordship.
Not,
I'm-
not to, we can't wait for your convenience. You have filed a petition which is bereft of any material. Which order,
Lordship, I will file additional
what
document.
was the
Lordship.
order by which it has been dismissed? Nothing.
Lordship, non-prosecution. Lordship, last 3 days, the three
I'm
occasion.
just passing it over. Get ready. It may come anytime. I'll dismiss it because there is nothing in this.
Lordship, I will reach the court. Kindly last 2 p.m. Lordship. After 2 p.m. Lordship.
Not
I'll
2 PM, but I'm passing it over. Okay. Next.
Lordship. Blessed.
May I please? Item 6, my lord, the impugn order,
Yes.
order annex to 2, page 13. The learned
Okay.
court below, while granting bail, of course, it is a admission by the accused that he will refund the alleged amount of 8 lakh to the informant within a period of 6 months. But some amount has been paid, and only condition, my lord, to be modified that 6 months period, lordship may kindly say 1 year. Amount
1 year.
6 months from the date of his
Release.
that is 22/2023, and in between also he has paid some amount, my lord.
No, this order was passed when?
This order was passed on
February
22
2023.
23,
We have crossed already more than 1 year.
more than 1 year. On February he has paid 50,000 and another 1 lakh. 1,50,000 already he has paid. Amount is not disputed. Only the time period, lordship may kindly.
Time you got 6 months. 6 months was granted in February.
My lord,
Now we are in June.
my lord.
Extra 4 months.
Crossed about.
Another 6 months, lordship may.
No, then I'll have to ask the other side. You can't, You are for the petitioner
My lord.
who you got the bail. Who is for opposite side?
Opposite is state, my lord.
But the money has to be paid to the informant
Yes, my lord. Complainant.
or complainant.
Yes.
The complainant is agreed. State has
It
nothing
is a
to
GR
do.
case. It is a GR case.
That's right, but state has nothing to do. State is not going to take the money.
No, no.
The money has to be paid to the informant.
Yes.
What to do?
6 months only.
So
Another
what
6
6 months you have already got the extension.
Yes, yes. But
Automatic extension.
that I understood, my lord. But only
You
6
have not
months.
implemented the informant also.
Since it is a GR case, I have not implemented him. But
How much you will deposit now?
my lord,
Now how much you will deposit?
my lord, 1 lakh I will deposit.
What is this? 8 lakhs sometimes.
Total 8 lakh, my lord. 1.5 lakhs already paid.
Out of 8 lakhs.
Yes, 1.5 lakhs already paid. Now only 6.5.
After 1.5 years, you paid 1.8.
ସେ 6 ମାସ ଭିତରେ ଆଜ୍ଞା 1.5 ଲକ୍ଷ ଟଙ୍କା ଦେଇଥିଲି ତାପରେ ଆଉ ଆରେଞ୍ଜ କରିପାରୁନି ସେ ଯୋଉ
Rest of money is 6.5 lakhs.
ହଁ, yes.
6.5 lakhs.
6.5 lakhs.
You have got about 1 year, more
One.
than 1 year.
तो 1.5 आज्ञा बर्तमान दे दउची लॉर्डशिप में काइंडली ग्रांट मी अनदर 6 months. The rest 5 lakhs I will pay.
Cannot be possible. If the 6 months, then I'll have to issue notice and call him. It's very big time.
लॉर्डशिप में ग्रांट sometime.
50% if you deposit, at least I can extend. You deposit 50% within a month and 6 months the rest of the year. That would be
50%.
You see, obviously we are not recovery agents.
Yes, yes, yes.
These are bail things.
Yes.
In the bail, this condition.
No, he has admitted to pay.
Ah, that's right.
That is lordship
it
में.
is your
Yes.
concession.
So
And
from
you
the
got the bail, now you are enjoying.
no, from the beginning I have said that it is admission on the part of the accused to pay
You
8
had
lakhs.
no capacity, why have you admitted?
He has admitted and he has
Desperate to come out.
Your lordship is right, my lord. Rest of 6.50, my lord, 3.25.
At least
Yes.
you deposit 50%, for
3.25.
another 50% I'll give.
Within a
some
month
time.
and then
So that it will be a balancing thing, you know.
rest
My
of
lord.
money will pay by the
That
6
is,
months.
Well,
Lord counsel for the petitioner and what is this petition is about? Condition.
condition modification.
The present petition is filed under section 439(1) of CRPC for modification of the condition of bail granted to the petitioner by order dated 20th February 2020 by the learned JMFC Gondia Denkara.
The bail was granted by the ADJ.
ADJ
Yes.
by learned ADJ come special judge.
My lord.
Vigilance, Denkana. On the admission of the petitioner, he was directed to return the alleged amount of 8 lakh rupees to the complainant within 6 months. 6 months. The petitioner could only deposit 1.5 lakhs, 1.50 lakhs till date.
Given to the informant.
Till date, and seeks for that time of 6 months to make good the entire payment.
Well.
At the outset, on the query from the court, the learned counsel for the petitioner submits that the petitioner would deposit 50% of remained amount of 6.5 lakhs within 1 month, and for remaining 50%, further period of 6 months is granted to the petitioner. In the
Remaining
event
50%, my lord, rest of money.
rest of the
Rest of.
and it is made clear that no further modification. It is made clear that no further modifications shall be entertained
Madam.
in the present matter.
Madam. Obliged.
This way. Yes, sir.
My lord, dispose method.
What will I do? Dispose of matter, again it is listed. So what will I do?
Modification.
You tell me, that's what I am asking. Oh.
File the knife.
Modification of what? You are very techno savvy. You don't have file anything, you come with a mobile and okay, tell me. From the mobile also you tell, no problem.
According to dispose of withdraw the petition.
Yes.
Modification.
See the mobile, don't see my face because everything is there in the mobile. See the mobile and tell.
Individual typing out of a CRLMC.
What is wrong? Which part of the order is wrong? Which part of the which order? You are talking about 14/3/2024 order?
Yes.
14/3.
Party filed this.
Sorry?
I was filed by the opposite party in this case, madam. This is the dispose of case, madam.
That's right, but there must be some. This is a modification application.
But
Yes,
not,
madam.
notification-
What is the modification? There must be some typographic error or something else.
The opposite.
My lord, in the, your lordship may kind of have a glance noting, my lord. CRLM से check.
Okay, modification allowed. ठीक है, ठीक है, ठीक है. ठीक, okay. It is everything is written here.
Yes, my lord.
You could have read the call citing, call list. Yes.
Item 8.
This is regarding what? Again, modification? Huh? I for modification. What is the modification? Let's see. See the modification.
Here is a requiring one more, 1 month more time to surrender.
Court is open hearing and transport. Or he seeks extension of time. 15 days extension of time. Okay, 15 days extension. Leave. By order dated, which order? Yes, by the order dated 2/4/2024, petitioner was directed to appear before the court below, appear or surrender before the court below on or before 30th April 2024. However, he could not surrender to the court below, and by way of linked application, he is seeking extension of time for another 15 days. For the reasons stated in the application is allowed. Petitioner is directed to surrender or appear before the court below on or before 15th of
July.
15 July. 15 days means 15 July, na?
22, my lord.
On or before 20th July.
Yes,
20th
22 July.
20th July. And avail remedy under law. Yes.
Item 9.
Yes, mine is also like
Your matter, this, according to 15/7.
sorry,
This is directed to issue notice to OP number 2 and 3.
2 and
2 and 3,
yes.
who are the minors, because he has not, in the cost title, it should be minorly represented through mother guardian. But he has not stated in the cost title.
Subject to
Therefore,
petitioner strictly complying.
Yes,
with
obviously.
by way of last and final opportunity on which time is granted to the petitioner to serve opposite party number 2.
2 and 3,
The opposite party number 2 and 3 are
minor, 8 to 8.
minors. They are being represented by
That has, he has not written minor, that is, it should be represented by the mother guardian.
who has moved this application?
That has been moved by the petitioner has filed.
Well,
Perhaps it has.
I am for the petitioner, my lord. I am for the petitioner, I will do it to the mother guardian. He represented for mother guardian, wrongly, I could not type it, I will get it typed. In course of the date, I will need copy, substitute the cost title copy by today.
The office objection pointed out by the court registry is directed to be cured by the counsel for the petitioner during course of the day. Mr. Mahapatra, during course of the day or by tomorrow?
No, in course of the day, my lord.
During the course of the day, lease the matter after, lease the matter on 15th, already there. Lease the matter on the date fixed. Yes.
Item 10.
May I please, madam? Your lordship set aside the NBW, but released on bail is not there, so now trial court has not released them, madam.
I have not said release on bail. I have only said that in accordance with the law, whatever.
Yes, madam. Your lordship set aside. Please to set aside, madam.
Yes.
But
I can't say that release on bail.
Learned
because
trial court set aside the NBW, but
Right, that is the usual order I pass. Set aside the NBW, grant you time to appear before the court, and avail the remedy under law. You
Yes.
avail the remedy under law. And
case of the year 99,
but
99,
I am
madam.
not on merit. I am not. 99, the case
And
is,
that, 4 times has been split up, my lord.
whatever.
So original record is not found. So the learned trial court
Whatever.
not inclined to release them by.
Have you surrendered?
No, I have.
Have you surrendered or not?
No, madam.
Then you have to surrender on apprehension. You can't. You may be granted bail. How do you know?
Yes, madam. 2 weeks may be granted, madam.
Then counsel for the which order?
Order dated 10/4/24, madam.
Order dated 10/4/2024. Petitioner was directed to appear before the surrender before the court below on or before 15th May 2024 and seek remedy available to him under law. For the reasons stated in the application, he could not appear or surrender before the court below and seeks extension of time for another 15 days. In view of the reasoning, in view of the reasons stated at the bar and I am inclined to grant another 15 days to the petitioner to surrender or appear before the court below and seek remedy available to him under law. Accordingly, the petitioner is directed to surrender on or before 20th of July before the court below and avail remedy under law. Yes.
Item 11.
May I please, Ross? My lord, petitioner is a cardiac patient, my lord. He is undergoing treatment and praying for extension of date of surrender.
Correct.
2 weeks, 2 months time maybe.
When the
My lord, 24/4
by order
2020.
dated 24/4/2024, the petitioner was directed to appear oblique surrender before the court below on or before 30th May 2024 and seek remedy available to him under law. For the reasons stated in the application and the statement made at the bar, the time for surrendering before the court below is extended for another 15 days.
My lord, some more time, my lord.
Extended. Extended.
1
And
month.
counsel for the petitioner submits that the petitioner is a cardiac patient and is not keeping well in view of the aforementioned statement and reasons stated in the application. The time is extended up till 30th of May, 30th of July, and the petitioner is directed to appear before the court on or before 30th July and seek remedy available to him under law. It is made clear that no further extensions are being there. Yes. In Saburi it made clear that no further extensions are being there. Yes.
Hello, with your lordship's permission, if your lordship may pardon me for that. Item 7, I am appearing for the opposite party. Order has been modified.
I've done it. Allowed.
No, I am appearing for the opposite party. What has been modified, my lord? Because the trial is
Whatever is written in the cause list, that we have done it.
only modified disposal of case, my lord. My lord, may I pray? Your lordship may.
No, there is a problem in the number. Instead of the IA, the main matter was disposed of. So that
Main matter was already disposed of.
already disposed of.
It
IA was moved. So in the IA that order was passed. That has to be clarified. So that we have
My
done.
lord, may I pray? Your lordship may keep it to after lunch. I will inform Mr. Bose.
No, nothing is there. In fact, the order was passed in IA.
Yes.
Inadvertently,
Oh, it
the
has been
number was not
reflected,
written.
reflected in the main.
So therefore the IA number has to be changed. Instead of IA, we have written criminal MC. In the place of MC, IA has to be written.
Then
That's all.
oblige.
There is typography. No substantial change here.
May please also, my lord. Petitioner wants to extension of time for surrender, my lord. Due to cardiac arrest, my lord, he is under treatment, my lord. Due to cardiac arrest, my lord, he is admitted in
By
KIMS, my
order
lord.
dated 21/5/2024, the petitioner was while cancelling NBW issued against the petitioner was directed to appear surrender before the court below on or before 15th June 2024 and seek remedy available to him under law. For the reasons stated in the application and the statement made by the Learned Counsel at the bar, the time for surrendering of the appearing before the court is extended up till
2 months, my lord.
2 months. No.
He is already, my
No.
lord, admitted, my lord.
Extended up till 30th of July. 30th of
My lord, this is the
July,
document, my lord. He is already.
and, the petitioner is directed to surrender at here before the
So,
court below on or before 30th of July. It is made clear that no further extensions are being.
Okay.
Yes.
Then will be passed over, my lord. Senior standing up.
Pass over.
Mr. Simon Das will accept it pass over.
14.
Item 14.
Yes, sir, item 14, paperwork, we have received paperwork and we commence in 20.
Sorry?
20. Let's say we have received paperwork. Let's say-
You complete the complete sentence. One word you are saying and eating the rest of the.
Let's
Yes.
say we have received paperwork and the matter comes under a order. Instead of a hearing, we commence in for 22.
In the
Tag in the weekly list.
Weekly. So, yes, matter is ready for hearing. List it on the.
Maybe tagged in the weekly.
Yes.
In this case, I have filed an interim application for early hearing of the case, madam.
Early hearing allowed. Argue.
Trial court record has not been received. Your lordship kindly have a glance to the notice.
Trial court record is not come.
Not received. So let the trial court record be called for. There are
Early hearing
registered.
application is allowed, but the matter the appeal could not be heard immediately for want of trial court record. And she is directed to call for trial court record within a week. Lease the matter after 1 week.
Okay, sir. Date may be fixed, no?
Date he'll fix.
Okay.
Can be reflected in the cause
Mr.
list.
Das name. Mr.
And
Das-
also-
Name of Mr. Das.
And also vigilance may be reflected in the cause list. So we are in doubt.
Acha, state of Orissa,
Ah.
wherever vigilance is there, write in bracket vigilance, so that they will not be confused.
So we are
Tell
searching for
the
the cause.
registry. Obviously, state of Orissa means how will they know? If vigilance is written, somebody will appear. Tell in the registry.
16.
Okay, sir.
Today, make a note and send it.
May I please, your lordship?
Yes, madam.
Your lordship, I'm pressing for the IA that was filed for stay of conviction, your lordship. In this case, your lordship, the order passed by the learned trial court is on the basis of only surmises and conjecture, your lordship. Your
You
lordship,
will be acquitted. Argue.
your lordship,
You will be acquitted. Why don't you argue?
I am ready to argue.
When you tell me, I'll put it in the weekly list. Get ready. We'll finish it up. Whenever you are ready, you tell me so that we can hear it and finish it up.
Your lordship may put it Monday, your lordship.
Weekly list I am including.
Yes.
Whenever you are ready, you please mention in the morning that I am ready so that we will fix it and hear it and finish it up.
Oblige,
Okay.
your lordship.
The same amount of time it will take.
Yes, your lordship.
It's better to hear and finish it up.
May I pray, Mr. Niranjan Maharana, additional standing counsel name may be
Mr.
reflected in the
Marana's name may be reflected in the list.
against
The
respondent.
matter is ready for hearing in all respect. List the matter in the weekly cause list. Whenever you are ready, you tell me, I can hear. Yeah?
8th, your lordship. Next week, your lordship.
You tell me 1 day before so that I can tell them they'll come ready and hear.
Copies of deposition and etc. we supplied to the current council for the.
That must be available on in the
That is not.
soft copy must be there.
You are the state. You are the state. You are prosecuting them.
No, in all the state cases, they are.
What,
supplied.
instead of entering into all this thing, you have a pen drive, come and
Soft
take
copy,
it. from
yes.
the- Why unnecessary? Both the side can take it. Both the side can take it. No
Lordship has given standing orders to it.
Get ready.
Accept- can
Get
accept.
ready, madam. You get the pen drive and take the.
I have obtained, your lordship.
Obtain.
Yes, sir.
And if you have a copy, give it to him unnecessary.
Obliged.
As a friendly gesture, not as a right. Because they are supposed to give you, not you. But friendly gesture you can give.
Obliged, your lordship.
Give it so that better can be heard and finished.
Obliged, your
Give a
lordship.
photocopy.
I'm handing over in the court, your lordship.
Yes.
Item 17.
My lord, on behalf of Siddharth Mishra, I have no instruction in this case.
This is against the conviction or what?
This is a bribery case, my lord, of rupees 1,000.
No.
It's an old matter. Yes, it's a.
That's right, but it is arising out of the conviction. What? Just see. It is vigilance. This is also vigilance.
Vigilance.
Today is for condemnation of delay.
No, no.
No, it's a very old matter, 14 years old.
All here.
Can you pass on that question?
Decide the order of the case. So please, take it.
Discharge application rejected notes.
No. This is a challenge to the order dated 27
Yes,
1
ma'am.
2010.
In a case of trap lots,
Accused so original counsel for special we had repeated that petition that there is no material of premium this wide in this petition the petitioner has assailed order dated 27 1 2010 whereby
discharge.
the application moved by the petitioner for the charge has been turned down. Since the matter is pending since 2010, no further 2010, and without there being a stay, the trial might have been proceeded. Learned counsel for the petitioner submits that he has no instruction on behalf of the petitioner in that in view thereof the petition is dismissed. Yes.
Item 18.
Item 18.
The conviction under section 13(2), read with the 13(1)(e) of the Prevention of Corruption Act, sentenced to undergo 1 year and a pay of fine of rupees 2 lakhs. DA amount 1,40,000. Small matter or prepare a
Maybe a small matter for my learned friend. It's a DA case, it will take some time. The lordship may tag it in the weekly list so that it can be heard chronologically.
What about DA case?
DA case can never be small. It needs a lot of calculation.
There's a lot of calculation involved, lot of things are involved.
What is the asset? What is the
Income, the balance sheet.
I'm putting it in the weekly list.
Yes, ma'am.
Weekly.
supplementary list.
Weekly.
Weekly, ma'am.
Yes. Matter is ready in all respects for hearing, list in the weekly list to be taken up in serial.
Ma'am, it's great.
In serial.
That decision which my learned friend is relying upon regarding stock witness, she has given a copy to me. Because no issue has been laid down here as far as the stock witnesses are concerned. Your Lordship, kindly have a look at that judgment.
Yes.
In fact, no ratio has been laid down. Only an observation has been made at para 1, the page 2, last but 4-5 lines. Your Lordship may kindly have a look with the sentence starting with before the court.
Yes.
It was established by cogent evidence that he had acted in a number of cases as a punch witness, and there were good reasons to believe that he was pliable witness not worthy of evidence. So far as the police witness is concerned, thereafter, there is nothing. No ratio has been laid down, my lords. My humble submission is that here no ratio was laid down. Secondly, his witness was not corroborated with other material witnesses. It is distinct from our set of facts.
So which criminal appeal you are talking about? Criminal appeal
Yesterday, my lord, it was there. Serial number 126 of weekly list.
Serial number will be-
item
126 of weekly leave.
126.
CRA 150 of 1992.
150
Of 1992.
92. Okay.
It's distinct manner. The set of facts are totally distinct and no ratio has been laid down.
No
It's just an
reasons has been
observation.
ascribed.
No reasons.
Okay. Okay. Yes.
Item 19.
Please, your lordship. Here I have challenged an order of the learned authorized officer, Special Court Cuttack, wherein your lordship may look at that order.
Final order?
No.
Entry.
An interim.
Yes.
While the confiscation proceedings were pending, my lords, the prosecution closed its case. I was called upon to give my defense. And I examined one witness. An adjournment was sought for by the prosecution to cross-examine that witness. And date was fixed. Thereafter, my lords, another defense witness appeared in the court. And I was told to come and cross-examine him. I submitted before the authorized officer that since one witness,
He's already waiting
Yes.
in line.
so he may be
So let
deferred to the next date. The PO flared up, my lords, and discharged my witness. So against that order, I am
But
before.
what has happened to the final order? Is there any stay?
Yes, there is a stay.
Why, what is this unnecessary? Hmm? You are unnecessarily delaying it. Give him a opportunity.
Unnecessarily it has been delayed.
They had come, my lordship. And without.
All these things, logistic issues are all right. But he has a right to examine.
They
First
are
witness
buying
has to
witnesses.
examine or second witness, why unnecessary? You are suffering a stay unnecessary. I'll vacate the stay, let him do whatever you want to do. The confiscation proceeding pending since
CC case of 2014.
just 14.
And there is, my lords, there is no presiding officer for the last 3 years. So even if your lordship vacates, my lords, passes it, it will again remain. in
And now also nobody is there. Show me, I'll set aside the order and where is that order?
That is the impugned order, my lords.
Uh,
Dated 13/4/2018,
Which page? 13.
page 7 of the brief.
7. Where is that?
Has your lordship got it? Page 7.
No, 7. 13.
13/4/2018, he writes, 3 witnesses, namely R. Appalaraju, Tahsildar, Tekali Mandal, Srikakulam District, AP, Santosh Panda, Branch Manager, Ulsurai Branch of SBI, Lahunipada in the district of Sundargarh, and Srinivas Mahanti are present in court in response to summons issued from this court to be examined as witnesses on behalf of the delinquents. Witnesses have filed respective haziras. Counsel for delinquents filed certain documents. Copy served. Learned counsel filed a petition for time for examination of witness R. Appalaraju, Tahsildar Tekali, on the ground that he has not produced any documents and may be directed to produce original documents of land records and be examined on a subsequent date. Copy served, heard. The reason he has given, so far as examination of Appalaraju is concerned, he was not directed by the court to produce any document, as there was no such prayer on behalf of delinquents when petition was filed to issue summons to the witness and other witnesses. So non-production of any document by him, prayer for adjournment on that ground is not convincing. Rather, getting an official witness of another state summoned through court and not examining him is nothing but abuse of process of court. And therefore it is rejected.
Your adjournment application is rejected.
Yes. And then he says witness is discharged.
The same witness, the
Yes.
Appalaraju.
Yes.
And your grievance is Appalaraju should be.
Yes, because my ancestral house is in Tekali, my lords.
Whatever, Appalaraju you want to.
I want the Tahsildar Tekali to be examined. He will say that I have ancestral agricultural properties.
Let him bring, write down. This is a petition filed by the delinquent. delinquent. The grievance of the petitioner is in the midst of his midst of examination to examination of R witness R Appelaraju Tahsildar, the other witnesses were called. Therefore, he sought an adjournment on the ground that once the witness Appelaraju is examined, then the other witnesses shall be examined. The trial.
No, my lords. Actually, what had happened is this. X was examined and his adjournment was sought for by them. Then this man came. Now the court, because of the fact that this thing has happened, he has not reflected the proper thing. He simply says that because I asked for time, he should be discharged.
Then I'll write it like this.
Yes.
Only. Sought for adjournment
as he had not brought the documents.
As the said witness had not brought the documents. The authorized officer rejected the application for adjournment moved by the delinquent. Hence, he approached this court. The matter is pending since
2014.
Here it is 2018.
Yes, before.
The present matter is pending before this court since 2018. 18 due to the stay. Where is the stay order?
Stay order, my lords, is there. First order.
The interim stay of further proceeding of confiscation proceeding number 11 of 2014 is operating since 20th April 2018. I heard Mr. Devashish Panda also for parties. I am of the pension review that the prayer made by the delinquent for adjournment ought to have been allowed by the authorized officer, and the appropriate opportunity ought to have been granted to the delinquent to examine the witness. In that view of the matter, the impugn order is set aside, and with the direction that the delinquents shall be given appropriate opportunity to cross-examine the witness with this observation.
To examine and cross-examine.
Examine and cross-examine.
No, I don't think it's
Who is asking for an adjournment that they are my witnesses?
It is made clear that the delinquent shall not seek unnecessary adjournment.
They are my witnesses.
Presiding officer has to be there.
Yes.
Then the question of adjournment will arise. Yes.
Item number 13 has been passed over.
My lords, may I pray this order may be uploaded and urgent.
Yes, today also. Yes.
But this is the appeal and final order. It will take some time.
13.
13. Let it come and.
It is passed over what? Passed over. 13. Weekly right?
Yes.
This is which year? 2011.
This is 11.
LCR has come.
Yes.
Okay.
I will file the written note of submission and.
Okay.
ମୁଁ ଆଜ୍ଞା ଗୋଟେ dispose of କରିବାକୁ କହିବି
କୋଉଟା କହିଲେ
25 ସେଟା ଟ୍ରାଏଲ
where are we are wait 1 minute, we'll reach there. 20th, 20 then 21.
Last date, your lordship, last date before, the lordship had the matter at length. Put up the matters the next week. Mr. Mahapatra has said the power has already gone to somebody, Mr. A.K. Mishra. The A.K. Mishra appeared on 13/5/2014, order number 4.
Yes.
Files been among.
I just in fact truly speaking I forgot everything.
Yes.
Truly speaking I have nothing is
Case is that.
written in the order also. Yes. Anyway, what is this case?
Case is the 1 lakh.
Use the mic. So I can
Case is that, my lord, 1 lakh amount has been dishonored. That I have
check this honor.
dishonor. I am a complainant. I filed both the case. Accused has lost the case. Accused has filed here before. Come before your my lord. Both the court he is lost. The lower court has passed the order 2 lakh amount.
You are the petitioner.
I am the petitioner complainant in the lower court. Here I am opposite party.
Because both the courts have convicted
Both the court convicted.
and
Appellate court dismissed the appeal filed by the accused and confirmed the order of lower court. Thereafter, he filed here criminal division. Criminal division, your lordship has passed subject 9/7/2013.
you are for Orissa Textile.
Yes, opposite party.
Okay. Who is appearing for petitioner?
My lord,
Last time also nobody appeared.
No.
my lord, in the occasion of dated 19/6/2024, my lord, your lordship was directed to intimate the concerned advocate, and I was intimated also, my lord. And thereafter, the advocate Arun Kumar Mishra power is there.
You are supposed to inform, you have informed, na?
Yes. Mr.
Who is
Mahapatra,
Mahapatra?
I have informed.
They submit that the client has taken consent from him.
Yes.
Mr. Arun Kumar entered appearance on behalf of the petitioner, but none appeared for the.
They have filed power on 13/5/2013, order number 4 of your lordship.
Then I'll dismiss it.
Yes.
Yes, ma'am.
What to do?
And the amount deposited in lower court may be returned to me.
All right, when the matter was taken up, I'll do one thing. I'll just pass it over. He may come, Mr. Arun Mishra. Last time he didn't appear. He entered appearance. I'll just pass it over. If he doesn't come, then I'll pass you.
It will take on after lunch.
At 2 o'clock, I'll take.
Yes.
You
Oblate.
just see Mr. Arun Mishra if you can
Yes.
find him.
Yes.
Ask him. Otherwise, I'll dismiss.
Oblate.
At 2 o'clock, I'm going to pass you.
Yes. Oblate.
You simply tell that please
Yes.
come. Otherwise, your matter is gone.
Yes.
Yes.
Oblate.
Item 22.
Yes. Yes, sir.
Your lordship said called for the status report.
22, 23 Guttai matter, same matter.
Okay.
But it was against the rejection of application for discharge. He is for one accused, I am for another accused.
Yes.
And there was another matter which has been deleted.
My lords, in 22-23 may be tagged with criminal division number 14 of 2014.
Stage operating in this matter.
Yes.
Yes, ma'am.
Stage
So
of-
this,
So why are you dealing?
Charges
Let's,
have not yet.
wait,
And
Mr.
item-
Das will be appearing in this matter. So lordship may call this matter tomorrow. Along with criminal division 14 of 2014. So that all three matters can be tagged and disposed of together.
Least the matter to 22-23 along with the
Criminal division 14 of 2014.
next time, next week.
Lordship, I am ready.
Next week they kill away the-
Supplementary list matters.
These are stage operating
Yes,
yes.
against charge.
Yes.
Here it will finish it up. Yes.
Yes.
11, 12
Okay,
minutes.
11th.
May 3 minutes. If it could be 13 minutes.
Huh?
It would be 13 minutes.
Saturday will you come? I'm ready.
Minutes. I'll.
Saturday.
I'm sorry, Malak. Yeah, lordships may 11 there is
11th matters. Yeah.
there is a genuine difficulty, Malak.
No
Lordships.
difficulty. Your case will be argued by your senior. Just see, senior is there. If anything remains, then again I'll adjourn it. Don't worry.
Malak.
So get ready and prepare a what you call written argument and come.
There's one thing may I just submit, Malak? There's actually an inquiry which I'm conducting by virtue of the order of the Honorable Court.
I'll accommodate that day. Don't worry. Let it be accommodated.
Lordship,
Yes.
may I be permitted to make mention?
Yes, yes.
Today I am ready with weekly list number 176. Just 172. Just I make a mention, Lordship will take note of.
172.
172 of the weekly. I will be coming after.
This is a criminal appeal.
Yes, criminal appeal.
Anybody is there?
Rijvi is there.
Mr. Rijvi, are you ready?
No, my lords. Just now, my senior is informing about it.
এই କେସ୍ ରେ ଲର୍ଡସିପ୍ କଣ ହେଇଛି ଏଇଟା କୋଅର୍ଡିନେଟ୍ ବେଞ୍ଚ ରେ ମୋ ପଟରୁ ଆର୍ଗୁମେଣ୍ଟ ହେଇକି
He
କନକ୍ଲୁଡ
has to be
ହେଇଯାଇଛି
ready. Otherwise, I have no issue. I have no
My
issue.
lords, let your lordship may tag it in the week. It is in the weekly list. Your lordship may fix a date. So on that date we can.
Let it be there. Whenever
Yes.
you are ready, you just
I will
coordinate
inform,
and
yes.
come and
Yes,
then
ma'am.
I'll take it up.
Yes.
I have no issue.
Next week.
Which year?
It is 2012 minutes.
2012.
12.
It's old matter.
Yes.
We can hear it.
Yes, ma'am.
If he's ready, just get ready. And you have a written submission?
Yes, yes.
Please give it to him so that he can.
Yes.
Yes.
Give it to him. You please mention, sir, anytime.
Yes,
I-
so next week,
Yes.
item 22 means interim order may continue.
That will continue. Yes. 24.
24.
This is regarding what?
I am the opposite party. That is the maintenance matter.
This is what? This is
Maintenance.
in order 22/1/2013. 22/1/2013. (125) petition.
Yes.
Who is appearing for the petitioner? You have a husband.
No, I am the wife, the opposite party.
Husband move application of 125.
Yes. No, I have moved. It was dismissed by the trial court. That petition has come to appellate court. Appellate court, he has allowed in favor of petitioner. That round, he has challenged.
You are for opposite party number 1.
Yes.
So
The
wife.
wife. Yeah.
And it is allowed in your favor. But the trial court order is reversed by the
Yes.
appellate
Yes.
court.
Here is reversing that.
And now the husband is telling me. What is the stage? 125.
I
Order
don't-
is passed. Some maintenance is.
That the order is the 2000.
2000.
Yes. Has not paid as.
It's pending since 2014.
Yes.
Who is appearing for? Who is appearing? You are getting any maintenance?
I think I have no instruction because that after a long time.
What is whether the marriage is still subsist or separated or a divorce petition is
I
filed?
have
What?
no instruction because after a long time it is common list.
None appears for the petitioner. The present petition is arising out of a proceeding under section 125 of CRPC. CRPC. The matter is pending since 2015. ₹20,000 is deposited. In the interest of justice, release the matter on Friday. Well, dismiss otherwise.
Yes.
Seek instruction by them.
Yes.
25.
It's 25 requesting for a passover.
25, the trial has already been concluded, the petitioner has been acquitted. My submission be recorded, affidavit is filed by the petitioner himself, tag A, madam,
This is against.
against rejecting my application for discharge.
Right. The present petition is arising out of an order by which the trial court has rejected the application of the petitioner for discharge. The matter is pending since 2017. Meanwhile, the petitioner stated to have been acquitted from.
Face the trial and acquitted.
Face the trial and stated to have been acquitted from all the charges. In view thereof, the petition is infructuous and disposed of. Thank you, madam.
My lord's the name of Mr. Lordship may observe Mr. Das' name, Mr. Sangram Das.
Thank you. ଏତିକି କହିବା ପାଇଁ ଆପଣ ଥିଲେ ମୁଁ ଭାବିଲି ଆର୍ଗୁମେଣ୍ଟ ହବ ଏଲସିଆର ମଗାଇଛି ତ ମୁଁ ଭାବିଲି ଆର୍ଗୁମେଣ୍ଟ ହବ ଇଟ୍ ସ୍ମଲ୍ ମ୍ୟାଟର ଦେନ୍ ଆଇ ହିୟର ଇଟ୍
ଖୁସିରେ ପଳେଇ ଆସିଥିଲ
Thank you very much.
26.
26, my lord, beg your pardon, my lord.
Yes.
Last occasion, I took time to take instruction, my lord. Though we take time, though we take instruction from the petitioner to pursue this matter, but we could not be ready today, my lord, because we do not have the LCR.
No, you are supposed to take instruction regarding what?
Sir.
You are supposed to take instruction regarding what?
Well-being of the
Well-being. He is there.
Yes. Yes. Good.
He is there and happy.
Yeah.
Okay, argue. You are not ready.
Yes.
Okay.
But we don't
This
have.
matter is pending since 2011.
Yes, my lord.
When will you be ready?
After 10 days. 10 days, my lord.
Why 10 days? You get ready next week anytime.
Is
This is conviction under which provision?
392, 341, 342.
341, 342.
Sentence?
Sentence, 1 month simple imprisonment, 6 month simple imprisonment, and 3 years security imprisonment, and
3
3,000.
years.
Yes, my lord.
How much you have already undergone?
Undergone.
You tell me the undergone, I'll dispose it up. Maintaining conviction already undergone. Finish. Why unnecessary? This is a matter. The incident has taken place in 2002. And that time he was, what was his age?
8 months.
He must be in fake end of his life.
36 years.
That time?
Yes, my lord. That time. 27. 27.
No, in the year 2011, when you filed this appeal, revision,
Yes.
he was 36 years.
36.
So now,
Now he's
49.
Anyway, he is a senior guy. Sending him to jail will serve no purpose. You tell me what is undergone or probation and everything will give and finish.
8 months. 8 months. 8 days. 8 days. 8 months. And 3 days.
You check and tell me at 2 o'clock.
Yes.
The period of undergone. See, the sentence is how much? 2 years. 2 years.
3 years.
3 years.
Yes.
You have undergone roughly about
1 year.
1 year
Yes.
without remission. So 3 years for which offense?
3 years for robbery.
No, section you.
392.
392. Anything minimum prescribed? 392, huh?
Yes, my lord.
Let's see if not prescribed. Concentrate on the quantum of sentence. 392. It's 10 to 10 years, that's all. And fine. There is nothing minimum. So I'll reduce it to 1 year. And with little fine. Come at 2 o'clock.
So order is there.
No, he'll come at 2 o'clock. He'll argue a little bit. If you think that is a case of acquittal, you tell me. Then I'll adjourn it. If it is not a case of acquittal, because 2 courts have held against you.
Yes.
So concurrent finding. So aiming at acquittal will be very difficult. So therefore, let us maintain the conviction, reduce the sentence to that of 1 year and with fine. And he has already undergone, with remission, it would be 1 year.
Yes.
9 months he has already undergone, a statutory remission and all, it will be about 1 year. Okay, 2 o'clock we come. Take it up and tell me the exact period undergone. Yes.
27.
Yes, sir.
That's a 95 appeal. On 27 to 24, the appellant was directed to seek the whereabouts. We were also directed, my lords. I am waiting for the whereabouts. Your lordship will fix it on 18 because similar matters are coming on 18th.
18th, huh? 18th.
Grateful.
95 matters.
Yes, ma'am. We have sent 2 reminders also because they have also done an inquiry, local inquiry, but they are not able to trace it, my lord. This being a 95 matter. On 18, my lord, I will give a clear picture, my lord. What has happened?
Now, are you facing any difficulty?
No
in
difficulty
your,
from the division side.
I
No
can do
difficulty.
something.
My lords, they are doing their work, my lords. They are doing their duty.
But I am making clear no adjournment will be given.
No, ma'am.
On 15th and
18th, yes,
you have to come with
yes,
instructions.
whatever the instructions will be there.
And if you have any problem, you tell me.
Definitely,
so
my
that,
lord. I will convey to your lordships.
Otherwise, also I can convey.
My lords.
Instead of. Otherwise, we can request the Director Vigilance
my lords.
to assist us how to sort out these matters, because I have told them, I met in an occasion, I told him, this is what the court is facing problem. Matters are pending from 1992. The counsel for the petitioners are not turning up. The entire responsibility is on prosecution now.
Yes, ma'am.
And something has to be done to know whereabout. Many of them might have died.
Yes. My lords, in between that, those matters which your lordship has fixed to 15th, I think 23 orders have been forwarded. Out of that, I have already received 10 to 12 instructions. They are working on it. They are working on it. In case, my lords, I found any difficulty, I will convey to my
so that any
It can be
assistance
disposed of.
can be rendered by the court.
Yes, ma'am.
No harsh order or anything
Lords,
of that sort.
and I do-
just request
I do understand all that.
somebody to be there to coordinate.
Yes,
things.
In case they don't come out with a concrete instruction, we will.
Let us see, 15th
Yes.
and 18th.
Yes.
Yes.
28.
May I please? 28 में noting में kindly be very.
LCR is not.
Let it come after TCR is received 1 week after. TCR may be called for. And may I pray that your lordship may fix it 1 week after the TCR is received.
Trial court record has not yet been tagged with the file, and is directed to court for the trial court record, and listed in the weekly.
1 week after trial
Date may be weekly, asila par weekly lege. Date may be fixed. Asila par weekly lege. ठीक.
29.
Item 29, my lord, I have instructed to appear in this case, but let it come next week any day. Today I am filing.
This
the-
is arising out of conviction.
No, my lord, the confiscation.
Final confiscation or interim?
Final.
Final.
Let it come next week, my lord, I will argue this case. Or any other date, my lord, as per your.
ଗୋଟେ week ଛାଡିକି ଦେଇଦିଅ. ଗୋଟେ week ଛାଡିଦିଅ. Mr. T.K. Mishra, Land Counsel for the petitioner submits that he has been recently engaged in the present matter. Therefore, he seeks an adjournment to prepare in the matter. Accordingly, leaves the matter on session. And made clear that no further adjournment will be.
Deeply.
Are you enjoying a stay?
No, yes, my lord, stay.
So if you are not ready next time, I'll vacate.
No,
the stay.
I am ready. I will be ready.
Be ready with that. These confiscation proceeding, particularly the interim order where stage operating, you people, you have to find out which are the matter you give me and list it. And if they are not there, I'll vacate the stage. Where interim, you tell me in all the matters will be listed one day. Then we'll see if they are not coming, I'll vacate the stage. Unnecessary pending. Yes. When are you going to give, sir, this list? You give it to in the supplementary list, everything will include. One day and we'll. No, you give the list. I'm asking him to get it listed in one day.
Yes.
Let it be Monday, Tuesday, whenever.
Yes.
It is listed. Once I'll give one opportunity to them. If they are not there, next day I'll vacate the stage. Otherwise, this matters will never be over.
Never ending saga.
Item 30 is of the year 2024. It has been mentioned in the cause list. The PP not to prepare. Let them prepare the paper book at their own cost.
Don't
Or
say
it-
paper book.
It may come in the usual course. When it is term which after 90 to 90 days.
Let the appeal be taken up in seriatim, list in the weekly list. In the seriatim it will come. We are in 92 appeals.
So
Passover.
May I pray that let them supply the copies of the position. They have with them.
They'll supply if they are there.
Yes.
You have.
They
Give a
have.
copy.
Yes, sir. If I have copy, I will send it.
If you have a copy, I can see the police. You get a photocopy and give it.
Yes.
Huh? Today, you please give it. So that.
Tomorrow.
Yes.
Passover item 3 was there.
Within this in course of this week.
Yes.
Mr.
Please
Das,
give, huh?
Mr. Das is ready to bear the expenses also.
Your lordship, Passover item 3 was there.
Yes, Mr. Naik. Item?
Item 3, Passover.
What is this matter is about?
Your lordship, this is for cancellation of bail. I am aware of the fact that your lordship, once the bail is granted, it is very difficult to cancel. But your lordship, this accused has violated all the terms and conditions of the bail. Not a single condition is left which he has not violated.
Where are the conditions? Let us see.
Your Lordship may kindly come to annexure 1, which starts from page 22.
Yes.
The condition starts from page 30, Your Lordships.
But the bail was granted way back in.
But Your Lordships, investigation is not complete in this case. And Your Lordships, I would like to read few lines from the case diary, even though the accused or his agents doesn't have any right to see the case diary under 172(3) of the CRPC. Let me read few lines, Your Lordships.
The FIR was the RC was up for which year? 2014.
That is a chit fund case, Your Lordships.
Okay.
This accused is an accused in Artha Tattva case where investigation is still going on, Your Lordships. Several high profile people were interrogated and till now also getting interrogated, Your Lordships. Lordship, let me read few lines, Your Lordships, from the case diary. 12 a.m.
The condition according to you is violated.
All the conditions, Your Lordship. Let me read the case diary, Your Lordships will understand. During the course of the examination of Sri Subrakant Patnaik, accused Vikas Swain appeared before me along with his advocate at about 12 hours in compliance to the condition laid down in such and such, and produced a copy of the High Court Order 25/2017 of Hon'Ble High Court of Orissa, which is enclosed. Sri Sudhanshu Sekhar Patnaik has revealed that he was introduced to accused Vikas Swain by Manoj Pradhan, uncle of Vikas Swain. Now, Your Lordships, Sri Vikas Swain did not cooperate with the investigation and stated that he doesn't know any Manoj Pradhan. As he was confronted with Sudhanshu Sekhar Patnaik, who was incidentally present in CBI office, the accused Vikas Swain got furious and threatened the IO, stating that it would be better for me not to further investigate the matter about him and his family members in Artha Tattva matter, or else he will drag me into trouble by making false allegations at different quarters, including trial court and high court. A copy of the interrogation report of accused Vikas Swain is enclosed herewith at 1:45 p.m. Now, Lordships,
Notice has been issued.
Notice has been issued. Now, Your Lordships, I want to read one more line, Your Lordships, what he's saying. Lordships, last 15 dates, Your Lordships, he has been continuously threatening the IO. And also telling that, Your Lordships, Lordship, allow me to read it. May I read, Your Lordships, if Your Lordships has time. Lordship, may kindly come to the bail order.
No, that's all right. I have seen it, but Mr. Manoj
Is threatening the witness. Your Lordship may kindly come to page
Manoj
41 for
has
a
been
moment.
appearing in this matter, senior counsel.
Your Lordship, the witness has given an FIR.
One is he is threatening the IO.
Threatening the IO, threatening the and he's telling I'll manage everybody. I don't want to tell whom to manage. I'll put it in a sealed cover and give. Very unpleasant things, Your Lordship, which cannot be told in open court. I'll put in sealed cover and give all the statements, Your Lordships.
Then, have you examined if the conditions are to be modified? If I'll modify the condition, will it suffice without cancelling the bail? You need some.
No, Lordship may kindly come to page 41 for a moment. Your Lordship may give me 10 minutes. I'll explain. Your Lordship may kindly come to page 41 for a moment.
41. Okay.
41 and 40.
But in the absentia, I'll pass it over them. Mr. Manoj Mishra has to be there.
Is he coming, Your Lordship? Sir is coming.
I don't know what.
But it was listed matter, Your Lordship. He should come.
Yes. Right.
Nobody has taken passover also on his behalf.
This is an application moved by the CBI for cancellation of a bail granted to the petitioner by order dated 11/11/2016. Mr. Naik, learned counsel for the Sarthak Naik, learned counsel for the petitioner, submits that the condition imposed by each and every condition imposed by this court while extending the petitioner the bail has been violated by the opposite party. He has been constantly threatening the IO, which is reflecting.
And the witness also, Your Lordships.
IO and the witnesses, which is reflecting from the case diary, which was read over to me during the course of hearing.
The witness has given complaint, which is in page 40 and 41.
He also submits that the present the opposite party has indulged in unfair practices which he can't utter, which he can't submit in the open court, and ready to place it before court in a shield cover if directed. None appears for the opposite party. None appears for the opposite party. In that view of the matter, in the interest of justice, the matter is adjourned to next week. It is made clear that no further adjournment shall be given in the matter. You come
Which date?
Next week, any day. 9th. 9th. And the seal cover thing which you are telling, you send your junior with that.
Yes, your
I'll
lordships.
see if he is threatening the IO, it's very serious thing.
Your lordships may also write that the IO should be personally present so that he can explain better also.
In view of the submission made by Mr. Naik, the IO of the present case may appear before court through virtual mode.
Yes,
virtual
yes,
mode on
lordships.
the next date appearing. Yes.
Thank you, lordships.
Yes, any password? And at 2 o'clock. 2 o'clock. Thank you.
ପ୍ରେଜେଣ୍ଟ ରହିବେ ସେତେବେଳକୁ ଯିଏ ଅଛି ଯେ ଅନ୍ କଲ୍ ଯିଏ ଅଛନ୍ତି ସାଙ୍ଗେ ସାଙ୍ଗେ
Item 168, I want to file no instruction memo on behalf of the appellant.
You want to?
I want to file no instruction memo.
Right on. 168. 168. Weekly 168.
As far as my lord CRLA 454 of 2011 is concerned, my lords,
446.
that has been abated. I think my learned senior is filing in 446 of 2011.
168.
446 of 2011.
Item 168.
168.
Yes. This is no, you have written since the registry did not take action.
No, again, in the last part, I have written that again I am
was filed before the registrar judicial.
Again, I am
What do you want? No instruction means your client has not given instruction. What registry will do?
That should be listed.
It is listed now. What
Yes,
to do
so
now?
that in the last paragraph I have written that no instruction from the appellant is again reported.
But it is, sir, it is against conviction.
Again.
Yes.
Okay.
Right.
It can't be decided on the basis of no instruction. If you want to recuse yourself, it's all right. You have to appoint someone else as in amicus curiae. I can appoint you also an amicus curiae. Because the file and everything is there in the capacity of a amicus curiae. You cannot say charge. Forget about your client. File is there with you.
Yes.
So why don't you assist the court as in the capacity of an amicus curiae? Forget about your client. Your client might not have given instruction to you. It's all right. No problem. You assist the court. This is a matter of
2011. 11 minutes.
You assist.
I am submitting the memo on behalf of Mr. Vasudev Pujari.
It's all right, but you can very well assist.
I can argue, but he is my senior. It will be difficult.
Okay, then.
When Mr. Pujari is giving no instruction memo.
Mr. Mishra, you assist them. You assist as amicus. You give the file. Mr. Vasudev Pujari appearing for the right honor. No, it's all right, but now he is filing new one. Take it. Criminal appeal 446 of 2001. Okay. Mr. Basu, on behalf of Mr. Basudev Pujari, and memo has been filed, inter alia stating that he has no instruction from the appellant, despite various attempts being made by him. Therefore, he doesn't want to continue appearing for the petitioner. Since the petition is arising out of a judgment of conviction and order of sentence, Mr. T.K. Mishra is appointed as amicus curiae to assist the court and lease the matter on the date already fixed. Date already fixed. Take him on record.
And let the name of the amicus curiae be reflected in the cause
Let
date.
the name of amicus curiae be reflected in the cause list. Get ready for the date fixed. Yes. 1 minute. What was the age at the time 2011? He was 2011. He was 59 years. Now must be
65. 65.
No.
70.
70 something.
73 minutes.
73. But the same time you get by next time. Mr. Rizvi, learned counsel for the opposite party, APS for the Vigilance Department, and he submits that he would seek instruction regarding the well-being and whereabouts of the appellant. The petitioner was 59 years old in the year 2011 when the appeal was filed. Appellant was filed. Let a report be sought for regarding the well-being and
Whereabouts. Yes. Yes.
Already fixed date, 2 years. Which is the date fixed?
And this has been
After 2
posted
weeks.
2 weeks after. In
Yes.
fact, this was mentioned yesterday itself.
Yes.
So, Your Lordship, we are pleased to adjourn it 2 weeks after.
Yes.
Item 5, Lordship, I filed the CLMA for restoration.
5 weekly. No supplement.
I filed the CLMA petition, Lordship, the restoration of order dated 17/5/2024, Lordship. I supplied the order still.
5, huh? What kind of application you are moving, sir? You don't file anything.
Lordship, I filed the registration copy.
This is, see, online filing you should do that. At least this order, at least you do a file. What is that?
Due to non-appearance. Due to non-appearance or?
You have been consistently not appearing.
On behalf of the Manoj Kumar Panigai, she is the conducting counsel and
Whoever it is, for petitioner none appeared. That's the problem.
Yes,
What is this case is about?
This is about, Lordship, the petitioner appointment as a
Passing of affair.
appointment as a assistant teacher.
Passing of FIR.
Yes, Lordship.
This is up for 2023.
And he has also filed
Charge sheet has been filed?
No, my lord. He has filed anticipatory bail. In that case, my lord, appeal number 6456
Kindly visualizing
that has been withdrawn.
Kindly visualizing the fact, Lordship. The petitioner
Tomorrow. Restored, lease the matter tomorrow. For
list this matter appropriate bench, Lordship.
No, you have, see, I would not have restored it because you have been consistently absent.
But the
Since you are coming and I am restoring it,
yes.
get ready tomorrow, argue.
Sir, my limited period, first or second parity, Lordship.
You, whatever you want to tell tomorrow. If it is appropriate case, I'll do it. Don't worry.
Yes, Lordship.
Get ready and come tomorrow. Okay.
Obliged, Lordship.
Maybe I may quash also.
Yes, Lordship. Yes, Lordship.
Get ready.
Obliged.
Yes.
Item 21.
Number 1, man. I have informed both the 2 Arun Mishra is there. One Arun Mishra say I have don't brief. Second inform his junior and lady colleague junior also.
What to do?
I'm an opposite party number 1. State right? So yeah, nothing. 138.
The present petition is arising out of order of conviction and a judgment of conviction and order of sentence passed against the petitioner by the trial court for offense under section 138 NI Act, and which has been confirmed by the appellate court. When the matter was taken up on 19/6/2024, none appeared for the petitioner. Therefore, this court directed the counsel for the opposite party number 1 to inform the learned counsel appearing for the petitioner regarding the listing of the matter. Again, the matter was taken up on 20th 28/6/2024. Mr. Smruti Ranjan Mahapatra, learned counsel for the petitioners, appeared and submitted that he has already given consent, so he is not willing to continue with the matter. At that stage, one Mr. Hon'Ble Mishra entered appearance on behalf of the petitioner, and a short time. Thereafter, none appears for the petitioner. When the matter is taken up today in the first hour, none appear for the petitioner. In the second call as well, none appear for the petitioner. In that view of the matter, the revision petition is dismissed.
You also be stated that the on behalf of appear Mr. S.R. Mahapatra already explained.
already.
His associate same.
But Smruti Ranjan Mishra.
Last date रे
associate of Mr. Smruti Ranjan appeared.
मतलब the amount deposited in the lower court will release in favor of the
Obviously. Yes.
opposite party number 1.
26.
That may be reflected so that it will not be a
Learned
difficult.
counsel for the opposite party submits that
Opposite party number 1.
Party number 1 submits that 1 lakh rupees has been deposited by the petitioner before the court below in lieu of what was that?
Order
Check amount.
Check amount.
The check amount of 1 lakh rupees has already been deposited by the petitioner before the court below. In view of the dismissal of the present petition, the same shall be written to, same shall be disbursed to the opposite party.
Opposite party number 1. Complainant.
Yes.
26.
Please, Your Lordship. My lord, the undergone
Yes.
in this the undergone in this matter is 14 months 24
14
days.
months 24 days.
Yes, my lord.
14 months 24 days.
Yes, my lord.
And what is the sentence about it?
Sentence was
3 years.
Sentence is 3 years. Rigorous imprisonment.
Offense?
392.
392.
May extend to 10 years.
No, my only submission is, my lord, in this, the one accused is acquitted by the trial.
Show me.
Judgment, trial court judgment.
There is nothing minimum, no? Sentence?
No. May extend to.
Yes.
Trial court judgment, kindly 15, para 15. Having considered the evidence of the prosecution witness, I am of a view that the
Which
prosecution.
paragraph you are reading?
15. Para 15.
1-5?
Yes.
1-5?
Yes.
Yes, read it.
Having considered the evidence of the prosecution witness, I am of the view that the prosecution in this case has not been able to prove the allegation, the alleged offense against the accused Jitendra Das beyond all reasonable doubts, for which he is entitled to get an order of acquittal. As regard the accused Virendra Das, I find the evidence of the victims PW4 and PW11 clear, cogent, and trustworthy regarding the offences that on 22/8/2002 at about 4 p.m. near village Lupur Singha, he, the accused, wrongfully restrained and informant, the informant, Birendra Meher, Laljit Meher, and Rajendra Sahu. It is also proved that on the above mentioned date, time and place, the said accused wrongfully confined the persons in the house of Das Malik for a night. It is further proved that on the above mentioned date, time and place, the said accused committed robbery against the informant and the aforesaid victims by snatching away their cotton bundles, money, and bicycles. Therefore, in this case, the prosecution has been able to prove the necessary ingredients of the offense under section 341, 342, 392 of the IPC against the accused Virendra Das alone beyond the reasonable doubts.
All reasonable doubts.
All reasonable doubts. As regards the offense under section 294, 394 of the IPC, in my considered view, the prosecution has not
How
been
many
able.
criminal cases are against you? See, the next, we come to the question of sentence, hearing and question of sentence. Read.
Yes, ma'am.
Question of sentence.
Yes.
1 week is a first offender and a young man.
341,
For which
342,
similar punishment should be awarded to him.
394, 294.
On the other hand, and APP submits that case, the convict is a habitual offender having a number of criminal proceedings against him. And in the present case, he has committed robbery against 3 persons on the highway, putting them in fear forthwith, for which he must be a terror in the locality. Therefore, the larger interest of the society, punishment will be awarded.
So PO is not applicable to him?
PO is
Habitual
not
offender?
applicable. 3 years sentence, huh?
Allowed.
Yes. 14 months, 24 days.
Allowed.
It can be reduced to this 1 year, 1.5 years. 1.5 years. But I'll increase the fine. Because you have robbed these people. Increase the fine to increase the fine to 10,000. 10,000, 357. That money will be paid. 10,000. Fine. Conviction maintained, sentence already undergone. The fine is increased from 3,000 to 10,000.
5,000.
Okay.
5,000.
You have robbed people, you are involved in many cases.
Authorized PO applicable.
PO is not applicable to you.
Habitual offender.
So what to do? Some deterrent, that's all. Yes.
Item 49 will be.
Why are you calling from 49? Mentioned.
Password, yes, ma'am. I have mentioned it. Yesterday it was password. File was not.
But what about this item 2 and all? These are very, very old message. 94, 2007.
Lordship was taken up to 1 to 21. Thereafter, appeal matters were taken up. In between from 121 to 20.
No, I'm talking about the weekly list.
Yes, my lord.
Item 2.
Item 2, my lords, weekly list is over, my lords. Up to 21, your lordship has taken. Thereafter, after 21, we have gone to criminal appeals. In between, those matters are left out.
Okay.
Those criminal revisions from 21 to 126.
Okay. But it's still in the board in the sense it's not disposed of. No? On disposed of then only.
Because criminal appeal matters, your lordship has taken up to 150, only 30 hours left. We have still 2 days left. So in between, your lordship may start criminal revisions from item 22. Some disposals may be there from
49, let us see. 49.
14. May I please, your lordship? In this case, my lord, confirming revision against confirming judgment, my lord.
Offense?
Offense 325, my lord. Trial court convicted under section 325 by 34 of IPC
Sentence?
for 1 year. And in appeal, my lord, sentence was reduced to 6 months, my lord.
Undergone?
Undergone only 4 days only during trial. Bailable, that is a 325 bailable offense, my lord.
When was the offense?
Offense was 2003, my lord. And the benefit of PO Act, my lord, should have been given. That has not been considered by the learned appellate court, my lord. Since they are the...
How many cases are there against you?
No antecedent as per the record shows that.
325, huh?
Yes,
What was the fine amount?
Fine amount 500 rupees. Lordship may extend the fine amount. And
Let us increase the fine amount to some.
Lost 2.
What do you say?
Well, Pidol 2 also lost 2 numbers of teeth.
How go to 500 lakh?
A dentist fee at least you pay. How much? I'll increase to 5,000. And insofar as sentence is concerned, PO. PO. Okay. Right down. Fine increase to 5,000, 500, and PO. Insofar as the sentence is concerned. Huh?
That will not suffice the dentist fees.
All are tribal person. Small case.
You are talking about the dentist fees today.
Yes,
This has happened.
2003, and that is the Koraput value, tribal person.
I paid 500 only. Yes.
Replacement.
117.
43 also 325.
40?
3
Yes.
That is also under conviction under 325. 3 years, 1,000 fine. He has already undergone about 5 months.
And appeal confirmed.
Reduce, confirmed, but reduce.
Reduce to?
326 has been converted to 325. And fine imposed is 1,000, 3 years conviction.
This is which year?
Year 2006, incident 2006.
Yes, Mr. Ragada, just see in this case also.
43.
Yes, see.
43. 325.
Initially it was 307. Convicted under, I think, 326. Appellate court converted to 325. And sentence is 3 years.
Yes.
Appellate court sentence?
It underwent 3 years.
Appellate court also.
He must have remained inside the...
Inside about 6 months due to the delay in filing the criminal revision petition.
Revision नहीं से तो trial बढ़ती है.
हाँ trial में
आपण देखो तो
Verify करते हैं.
verify कर दियो तो report काम दियो तो.
पहले ही inside देखो.
आपण पोजीशन ते दियो. अच्छा. And if 6 months he has already undergone.
During
revision period को
6 months.
अरे आगुर भी जाइथियो. मास 2 मास जाइथियो. तो हेला वर्ष
307 ना बेसी थियो. अपील थियो.
काफी थियो.
देखि दियो. Verify कर.
देखिए कौन तो so that we can I can take it up and finish it.
It's a trial court. Appellate court has given RI 5 years, not 3 years.
Trial court to 326. A trial court has given 5 years, and appellate court has converted to 325, made it 3 years. That's what he says.
5 years.
You see, 43 na.
By the assistant session judge. No, sorry.
Come to sessions court. Take 1 minute. I will also.
Yes, madam.
देखिए
And injured my lord PW 18.
Medical evidence,
My doctor page 12 my lord.
just see, tell me.
Sorry, sir.
My lord, the doctor PW 16. He has opined that on police requisition, he examined the injured and submitted a report. On the
Tell me the injuries, whether in vital part, whatever.
As per the doctors, he found 2 laceration, one size 3:3 over the slap and one size 2:2 over the right hand of the injured Ramesh. And both the injuries found in the injured were grievous in nature.
Where? What is the, which part?
One is slap, my lord, another is on the right hand. One is on the right hand, another is on the slap, my lord. And both the injuries are grievous in nature.
What has he used? What is weapon?
Weapon, my lord. One stone, my lord.
Stone. Picking up from there. Let's see, picking up from there or carrying it. And the fit of anger, he might have picked up a stone and beaten it.
But he has pelted a stone on the head of the Ramesh and trying to throw the stone again. He caught his hand and snatched the stone from him, and that time PW reached there. That was picked up, my lord, from the.
There is no intention as such. What might have taken place? 27 years in the year 2010.
Incident is of 2006.
Fine 1,000, sentence 3 years. Just see, undergone period. Let's see. Yes, next.
117.
Tell me, immediately.
On date 17, my lord, FAR 341, 354, 506. Charge framed under section 341, 354, 506.
117, huh?
117.
My lord, FAR under section 351, 41, 354, 506. The London Trial Court acquitted under section 351 and 506, convicted 354 for 1 year.
354.
For 1 year. And without file.
Appeal?
Appellate court.
Confirmed.
No, appellate court acquitted under section 354. Convicted under section 323 when there is no charge at all. And convicted for 1 month. Convicted for 1 month, fine 500. In lieu of that, 10 days for SI.
Trial court acquitted all the offences. Convicted on 354. In appeal, 354 acquitted and 323 convicted. चलो पीओ को छोड़ देगा तो पीओ को लिख ले yes
Item 30. Item 30.
30 yes yes
my lord.
304B connection. 304B.
304B and 498 and 4 defect, my lord.
Convicted.
Convicted. Under section. Convicted, my lord. To undergo imprisonment of 7 years, my lord.
Husband.
Husband and parents-in-law, my lord.
And appeal?
My lord.
Appellate court?
Appeal confirmed, my lord.
Confirmed.
Yes. Within 8 months of her marriage, my lord.
death occurred.
Yes. My lord. Case is, my lord,
Yes.
that marriage took place on 26/4/2007.
Yes.
One thing, my lord,
Hmm.
by the time father-in-law aged about 72 years, my lord, the father of filing.
अच्छा अच्छा दिया
2011.
My lord, mother-in-law 62 years.
Okay. Yes.
Date of marriage 26/4/2007, but died on 30/10/2007. Allegation, my lord, that they were demanding some money, demanding some dowry articles, my lord, that mobile phone. But whenever the PW13, my lord, had come to his house, that from different state, my lord, Bihar, they are belonging to Bihar, my lord, married at Raurkela, but staying at West Bengal. And when the allegation, my lord, only basing on the statement of the PW13, who happens to be the brother of the deceased, he says that I had come to the place of the matrimonial house of the deceased. She narrated that she was being tortured due to demand for dowry, and he has sent a letter stating about that he arranged for the demanded articles. Only that was stated. So my
That letter is exhibited.
That is exhibited. Exhibit 10. In Hindi, my lord, it is written. That is in Exhibit 10. And basing on the evidence of the PW13 and Exhibit 10, conviction has been sustained, my lord. But my lord, their allegation is that demand of torture, and the defense pleas that she was not interested to marry the petition appellant number 1, my lord, husband, my lord. And marriage he had he has promised to marriage to another person, my lord. They were staying there, staying with him, her, suppressing the fact that has been done. Thereafter, she could not adjust and committed suicide. This is, my lord, this is their allegation. This is the defense.
Suicide by hanging.
Suicide by hanging. And as far as, my lord, if your lordship will go to, I am going to, FR, of course, it is in Hindi. Going to judgment, lordship kindly go to page trial for judgment, my lord. Just I am reading from beginning, my lord. I am reading. Prosecution case, just I am placing for the prosecution case. What is the
I understand prosecution case. Come to the evidence.
Evidence, my lord.
What is the reasoning?
PW13, my lord. Your lordship comments. PW13, my lord. I know the accused persons. Damodar Singh, my brother-in-law. Damodar Singh is the husband, my lord, appellant number 1, my lord. Damodar Singh.
Come to the trial court judgment, para 7.
Trial court judgment, my lord.
Para 7.
My lord, para
7. What is the maximum sentence?
Ten or 9.
Page 7. Page paragraph 7.
Paragraph
7.
In the, I am reading from the paragraph 7, my lord. Page 5 of trial court judgment. In the present case, it is admitted fact that the deceased died due to asphyxia, due to hanging, suicidal. It is the allegation of the prosecution that the accused persons demanded dowry after marriage and tortured the deceased and assaulted her. It is further allegation that the accused persons demanded a gold chain, mobile set, and as the parents of the deceased could not fulfill their demand, they tortured her and ultimately killed her. In order to prove this, the evidence of the PW 13, 14, and 15 is very much material. 13, 14, 13 means the brother, 14 is the father, 14 was the father, informant.
Brother, father, and
Mother.
parents.
And the 14, 15 are the hearsay from the PW 13. But court did not accept it as a hearsay, though they stated that they have heard from the PW 13. Whatever it may be, my lord. Evidence of the, in order to prove this, evidence of the PW 13, 14, and 15 is very much material. PW 13 is the brother of the deceased, and PW 14 is the father of the deceased and the informant of this case, and PW 15 is the mother of the deceased. The other witnesses examined in this case are seizure witnesses, independent witnesses, medical officers, and also investigative police officers. So, the entire case rests on evidence of the PW 13 to 15. Besides other circumstantial evidence, there is no direct evidence that accused persons killed the deceased and hanged her in the bedroom. Rather, the medical report shows that the death was due to asphyxia due to hanging suicidal. PW1 is the medical officer. According to him, on 31st 10/2007, he along with the Dr. Svetalina Jena conducted postmortem examination over the dead body of the Nidhi Singh, deceased wife of Damodar Singh. According to her, the cause of death was due to asphyxia due to hanging suicidal. According to him, there were queries with regard to the cause of death of the deceased, but the death was due to asphyxia due to hanging suicidal. PW8 is the medical officer who conducted postmortem examination along with PW1.
The suicide is
Suicidal is approved. Suicide admitted.
the only thing is
Their allegation that they committed a murder and hung.
that is not believed. It's
And
forget.
pending in the court, my lord, the death is not normal course.
Only on
Natural,
the
not natural.
presumption, only on the question of
No, no.
presumption.
And that too in the house of the in-laws, my lord. 313, my lord, B. 113 B is my
And
lord.
demand of dowry is proved in view of that letter written by the deceased
And so also the
before her death to the brother,
and so also
My
the
lord.
evidence.
which has been exhibited.
My lord, exhibited only on the basis, my lord, because it is a prior to occurrence. What the prior to occurrence, they say that there was a demand of dowry by virtue of the letter, and taking into account convicted, my lord. My lord, if your lordship will see that letter also, letter is also contrary to the FIR, my lord. That letter was stated to be given on 13/10, my lord. But in FIR itself, it shows it is 16. That is different date. And though nowhere it is expressed,
It is only one letter. That's
one letter. And though nowhere it is expressed, as far as the investigation is concerned, prosecution case is concerned, that was written on a marriage card. That letter was written on a marriage card that was not shown in the prosecution evidence. But during evidence, it was stated that it is the marriage card. But date differs.
That is exhibited. You have
Exhibit 10.
Have you cross-examined to that effect?
Cross-examined.
PW 13. Let us see
PW 13. You lots may kindly go to PW 13.
Let's see PW 13. Yes. Yes.
I know the accused person Damodar Singh is my brother-in-law. Damodar Singh was married to my sister Nidhi Singh on 26th April 2007 at my village. At the time of marriage, a cash of 1.5 lakh were given to them.
You concentrate on one thing. What I am aiming at is,
Yes, my lord.
mother-in-law, father-in-law. What are the evidence against them?
Mother-in-law, father-in-law, they heard from the PW 13.
Is there any direct evidence against mother-in-law?
No.
Yes, Mr.
My lord. My lord,
At least we can.
Though my lord, they stated that Konikre Kathavarta houtila boli kahilebi, phone has not been seized.
At least we can think of acquitting these two people. The sentence cannot be compromised because sentence is minimum
7 years.
Minimum.
That can't be reduced.
But they can't, my lord.
So, if you can't reduce the sentence, then the only thing is either acquittal or same sentence.
Yes.
And I'm aiming at finding out way how to acquit the mother and father.
Yes, but
Because they are 72 years in that.
113B, my lord, Evidence Act, my lord, presumption as the doubt death, my lord. As to
That's
doubt.
that presumption is.
That is there, my lord. Presumption, my lord.
Hey, what is the evidence against the mother-in-law, father?
Father and mother-in-law, my lord.
Let us read for 13 whether
13,
he says anything about mother-in-law. Let us read complete.
13.
In the letter, has it in the letter it
No,
tell anything about mother-in-law, father-in-law?
Torture part is not there, only says that you
Demand
arrange
of dowry.
demand of dowry. You arrange these things, say, mobile set and gold chain.
Who demanded the mother-in-law, father-in-law?
Nothing
or
is
the husband?
expressed, my lord. That is letter does not show also there. That is by defense.
So let us read
Read up
13
13.
because 13
Read up 13.
appears to be one of the
My lord,
important witness. Yes.
at the time of marriage, a cash of 1 lakh and 1.5 lakh were given to them as per their demand, along with other household articles. After the marriage, they were residing at Noya Bazar, Raulkela. On 10/7/2007, I came to meet my sister at Noya Bazar, Raulkela. At that time, my sister told,
This is important, man.
my sister told that the accused persons were threatening
All accused persons.
all accused. Yes. General allegation, my lord. Accused persons were threatening to kill her, as chain, gold, ring, mobile were not given to them. She was not leading a peaceful life. Then on 13th, I told all those facts to my father. My sister gave me a letter describing all her miseries on the marriage card. I am acquainted with the handwriting of my sister.
On a marriage card. This is the
marriage card. But that is confronted and contradicted to the my sister gave me a letter describing all her miseries on the marriage card. I am acquainted with the handwriting of my sister. Exhibit 10 is the said letter. The accused persons had killed my sister and hanged. I was examined by the police, my lord. Then my lord will come to cross-examination part, my lord. After the marriage of my sister, I came to Raulkela for 3 times. On 10/7/2007, I came to Raulkela and went to house of my sister. On 13/7/2007, I returned to my house at Chapadani, and I stayed for 2 days in her in-laws house of my sister. After 1 month of the death of my sister, I again came to Raulkela.
10th July to 13th July.
13th July.
Then if the letter is given, it should be
within that period.
Within that period or before that. She might have written it before
Yes,
that.
yes.
And what is the date of the letter?
Date of letter, they say 13. But in FIR, they say that is 16.
But what is the letter? Where is the letter exhibit?
Letter exhibit 10.
See the exhibit itself.
Exhibit 10.
Exhibit 10.
Exhibit?
Exhibit 10. Written in Hindi, my lord.
Oh, no problem.
More by oxygen, pori habo, pori habo. देखो अच्छी कार्डटा पछला है କିନ୍ତୁ କ୍ରସ୍ ଏକ୍ସାମିନେସନ୍ ଏମିତି ବି ପଢିବ ଏଇଟା ହଉଛି
Yes, exhibit 10. Is there any date?
डिफेंस रे जा कहया कथा मैरिज कार्ड जा
No, date is at the top. 13/7/2007.
13/7. Yes, 13/7. That is 13/7. That is
date might have where the document itself is there.
document 13/7 କହୁଛନ୍ତି କିନ୍ତୁ
that is one argument. Doubt to the letter.
ସେ କହୁଛି ତାଙ୍କର ପ୍ଲି ରେ କହୁଛନ୍ତି ଡିପୋଜିସନ ଫାଦର ଦେଲେ ସେ କହିଲେ ମୋ ମୁଣ୍ଡ ହାତ ଭଲ ନଥିଲା ମୁଁ ସୋଲ୍ଡ ଲେଖିଦେଲି କହୁଛନ୍ତି ମୋ ମୁଣ୍ଡ ଭଲ ନଥିଲା ମୁଁ ଇଏ କରିଥିଲା ମୁଁ ସୋଲ୍ଡ ଲେଖିଦେଲି କହୁଛନ୍ତି how far that can be accepted. That is a question. Sir, I'm reading from the cross-examination part, my lord.
I returned to the home.
I came to Raulkela and went to the house of my sister. On 13/7, I returned to my house at Chadpani. I stayed for 2 days in the in-laws house of my sister. After 1 month of the death of my sister, I again came to Raulkela and I saw the accused persons at the police station. I was examined by the police. I, along with my father and one Bablu Singh
Came to Raulkela.
came to Raulkela. The father and one Bablu Singh came to Raulkela. It is not a fact that I have not stated to police that when I came to Raulkela, deceased sister told me that accused person threatened to kill her. It is not a fact that I have not stated to police that she was not leading a peaceful life and that on 13th October 2007, I told all such facts to my father. It is not a fact that I have stated before the police that my sister had written all her miseries on a marriage card. It is not a fact that I have not stated before the IO that the accused persons had killed my sister and hanged her. It is not a fact that handwritten writings on Exhibit 10 is not the handwriting of my deceased sister. It is not a fact that we have fabricated a case against the accused persons with fabricated document. It is not a fact that my sister's marriage was not performed as per her will, for which she was not happy.
Yes.
It is not a my lord. And all these things, my lord, all these things comes in paragraph 4 that has been duly confronted to
What are the material you have? How will you doubt this witness?
My lord, your lordship, the paragraph 4. These are not stated before the police, my lord. On the basis of which conviction has been held. This is the basis, my lord. Those materials on the basis of which that is not corroborated. Sole evidence is a PW 13. If your lordship accepted, sole evidence is a PW 13. And PW 14 and 15, they are the hearsay witnesses.
No, they are hearsay.
Hearsay witnesses. And PW 13, if your lordship disbelieve
The basic material is PW 13 and that letter.
Letter, my lord.
These are the two.
That letter is disputed as far as the written on the that is confronted duly to the IO, and as far as those statements basing on which
Let's see, IO.
lordship PW 12. 12 no, so that last
12. No,
19. So that is
19.
19.
Yes.
19.
Come.
Nahi.
Which part?
Shall I read from total? No,
Which part is relevant part?
Confrontation, my lord. My lord, paragraph 11. Paragraph 11.
Yes.
I have examined Nitesh Kumar Shah, PW 13. I examined him on 14/11/2007. I have not examined him thereafter. He has not stated before me that when they came to Raulkela, his sister had told him that the accused persons had threatened to kill her. He has also not stated before me that he informed his father that his sister was not leading a peaceful life. It is a fact that he has not stated before me that his sister had written all the miseries on her marriage card. And it is a fact that he has not stated before me that the accused persons killed his sister and hang out. That is the
how this letter was seized? Where from?
My lord?
It was seized from the PW 13. How it has come to the
PW
court?
13, my lord. Your lordship, a seizure list is there. IO statement is there.
IO seized it from whom?
Seizure list. One written letter of Nidhi. Circumstantial seizure is उक्त केस तदंत समय रिपोर्टकारी श्री कृष्णा साही साक्षी मान उपस्थित रे दाखल देवा से PW 13 करी जबत कला करागला और तांकर एक कविता नकल तांको दिया गला. Handwriting letter also not proved, though he says that it should be handwriting. That was or court felt that another notebook was seized. Court said that this notebook is in appears to be.
So you tell me how this letter, which has been exhibited, came to the police record.
My lord, from the my lord, your lordship.
PW 13.
PW 13
gave it.
PW 13.
PW 13 gave it.
PW 13 gave it
to the investigating officer.
My lord, circumstance seizure, my lord, seizure list, my lord. उक्त केस तदंत समय रिपोर्टकारी श्री कृष्णा साई. कृष्णा साई तो PW 13.
तो सर अभियुक्त तो ठीक है.
So he has PW 13, my lord.
Hmm.
Nityan Sai. My name is Nityan Sai. Krishna Sai is the father. Krishna Sai is the father, informant. Sorry.
So,
Nityan, PW 14.
14 gave it.
14 gave it. ଦାଖଲ ଦ୍ୱାରା ଯାକୁ ଦାଖଲ ଆଉ ତାଙ୍କର ଏକ ବିଧାନ Krishna Sai. Krishna Sai is the father of the deceased. The conviction is based on only, my lord, first of all, my lord, uncorroborated testimony, my lord, and court presume that might be done, and surmise that conjecture, my lord, all the accused persons have been convicted, my lord. If I read, my lord, your lordship, appellate court judgment and trial court judgment, your lordship will get it.
Lord, we have gone through the evidence of PW 13.
PW 13, yes.
I am still struggling to get out of this evidence.
And PW 14 also, my lord, she stated that with regards to others accused persons, my lord, actually, I know the accused persons, the others called such and such.
Try and read the content of the letter.
As a gold chain.
Content of the letter, my lord, but that is in Hindi.
Oh, then Hindi.
Hindi रे अच्छी है, इंद्रा टिके पढ़ी होनी थोड़ा ठीक भावे. Record रे.
I'm trying to read that only.
टिके जदि भल्ला judgment बाहर कर
दिया. बाप हमको क्या दिया?
टिके बाहर कर दे भी हुए तो और खाली गाड़ी पड़ गई. नहीं.
क्या है?
ऐसे उधर से. हाँ. तार torture part जो कहूँचांती हमारा 304 भी presumption जो torture part दरकार है just prior to occurrence there might torture. That part is not there. Probably what is the defense case is there? Presumption 113. हाँ सही उड़ा. Immediately before the death, my lord.
Brother was there on 30th occurrence taking place. And also, my lord, the father stated that my daughter informed me.
The incident has taken place on 13th.
My lord.
From 10 to 13.
10 to 13.
Brother was there.
My lord.
Brother was
when he left.
13 से कोई पहुँचिला और 2 दिन मुथिली.
That day only this has.
Maybe 10, 11, 12 की 11, 12, 13.
So therefore the statement of PW 13 assumes more important.
Yes,
because he was there with his sister for about 3 days. And during that day, those days while leaving the house, that time the sister had given a letter to him narrating everything, what has been happening with her. And thereafter, once he left the place, the sister committed suicide. So therefore, the evidence of PW 13 assumes very important and a quick succession that this has happened.
But that is to be proved, my lord, by the letter. That is proved with strict proof, my lord.
That is
exhibited. Mere exhibition is not. But it should have been sent to the my lord handwriting expert, whether that was the signature of that deceased or not. But that has not been brought into record.
Where is your suggestion to that effect?
Huh?
Where is your suggestion to that effect?
Suggestion, huh? Suggestion.
Then?
That's not police.
This is not written by the deceased. All these suggestions should have come. You have accepted that while examining PW 13. Just see a cross examination. How will you get out of it? If you want to create a doubt insofar as this letter is concerned, the cross examination to the that is the reason I am asking. How has it come on the police record? Whether it was given by PW 13 to the IO or IO has seized how it has come to the
that is suggestion, my lord. Suggestion paragraph 5. Suggestion paragraph 5. PW 13
yes, read it.
It is not a fact that the handwriting on exhibit 10 is not the handwriting of the deceased sister. That is
suggestion. That is
suggestion. Yes, suggestion.
But how has it come to the police record? You tell me. Was it seized by the police from
police?
From the brother of the
police,
or brother has given it?
Father.
Production of the
Father of the deceased. No, 13 no. 14. Like how
Father has given to police.
Father has given to police. and PW 14 is the father, my lord. May I please read, my lord, 14? I know the accused persons. Accused Damodar Singh is my son-in-law, and accused Baldev Singh and Kalavati Singh are my Samudi and Samuduni. Nidhi Singh, my daughter, married to the accused Damodar Singh on 26th April 2007 at Patra. As per the demand of the accused persons, I gave 1.5 lakh cash and gold ornaments and other household articles at the time of marriage. After marriage, accused Damodar Singh and my daughter were residing in Noya Bazar, Raulkela. As the gold chain was not given to the accused Damodar Singh, so the accused persons, my lord, used to threaten and assault to my daughter. And my daughter informed me this fact over telephone. Accused persons were also demanding me Nokia mobile 63 set. Accused persons were also demanding for a motorcycle. Demanding for accused persons were said mobile. Accused persons were also demanding for a motorcycle. Then I sent my son Nitesh Sai to ascertain the truth. He came and ascertained that the accused persons used to threaten and assault to my daughter on the demand for the gold chain Nokia mobile handset. My daughter also sent a letter through my son, Exhibit 10, already marked with the said letter. While I was arranging for these articles, accused persons on 30/10/2007 killed my daughter. On 30/10/2007 morning, while I contacted over phone Jitu means the brother of the appellant number 1, my lord. Jitu informed me that my daughter was died. Then I went and found the dead body of my daughter at IGH Mork House.
See, what you do is you try and find out what is written in the
letter.
From the letter, contents of the letter,
Yes.
you may get some defense. If the letter doesn't disclose anything, detail of
Letter, what the prosecution defense case is, the letter is the only demand said that you arrange this thing.
But unless you read the
yes,
letter,
my that is a difficulty, but there are difficult on my part.
you try and find out
yes.
the letter part. Otherwise, you have a very difficult case. And I am only aiming at one thing, that at least the mother-in-law, father-in-law should be acquitted.
Lordship,
because except general allegation, I don't think there is anything.
Except general.
Mother-in-law, father-in-laws are very old people, 72 years and 60. Why should they be penalized? I'm trying to find out some way out to acquit them. I'm not aiming at the husband at all. And if you read the content of the letter, please
yes, that is very important.
Concentrate and try to read it and try to write it down.
Yes,
because everything is based on that letter.
Yes.
Because the PW 13, the trial court say and High Court, appellate court says PW 13's testimony is found corroborated with the contents of the letter.
Yes.
If the letter says something else,
yes,
and PW 13 says something else, you may have a good case.
I'll verify now. But one copy.
Please try, because
I
can't reduce the sentence. That's the whole difficulty.
My lord,
otherwise, I would straight away reduce
my lord,
the sentence and
correct.
finish it up.
Only I can argue for the
Minimum is 7 years. That's the whole difficulty. I can't alter the offense also.
Yes, that is correct.
If I say 498 only, simpliciter.
Yes.
Suicide is there, then the presumption operates. I can't convert the provisions also. So therefore, you are stuck in this technicality. Find out undergone how much?
How much 306 case you want? Abatement to commit suicide. Suppose abatement nahi 306 nahi. Nahi 304 भी रही थी. ये जो abatement तो दी था भी 306.
Find out some. Way out, how can,
My lord, I'll see the record.
how can we can help you?
Yes, my lord.
And undergone how much?
ଅଣ୍ଡରଗନ ଭିତରେ ଥିଲେ ତ 2 ବର୍ଷ ଥିଲେ ତାପରେ ଟ୍ରାଏଲ କୋର୍ଟ ଜଜମେଣ୍ଟ ପରେ ପୁଣି ଭିତରୁ ଗଲେ ପୁଣି ତାପରେ ବେଲ ବାହାରିଲେ କେତେ ମୋର ଏକ୍ସାକ୍ଟ ଡେଟା ସେ ରେକର୍ଡରେ ଏଲସି ହଁ 2 ଇୟର୍ସ ସେତେବେଳେ ଥିଲେ କେତେବେଳେ ଟ୍ରାଏଲ କୋର୍ଟରେ ଧରା ଥିଲା ବୋଧେ ଶେଷ ପର୍ଯ୍ୟନ୍ତ ଥିଲେ ବୋଧେ ବି ହଜବେଣ୍ଡ ଥିଲା ସେମାନେ ବୋଧେ ବାହାରିଥିଲେ ଆଉ ଜଜମେଣ୍ଟ ପରେ ପୁଣି ରହିଥିଲେ ଦେଖିଲେ ଆଇଲ ଭେରିଫାଇ ଦ ରେକର୍ଡ ଭେରିଫାଇ କଲ
Minimum is 7 years. That's not less than 7 years.
minimum punishment
Find out sufficiently you have undergone. You should be acquitted.
Yes.
You got the penalty adequately. Technically, you should be acquitted. Otherwise, you have gone through the hell. Find out. Please try it. If you can get something, definitely you can try for acquittal.
I will verify from the record, my lord, because the copy to be asset देखियो हाँ.
And with remission, how much it would be? 3 years with remission, chapter remissions.
Chapter?
Yearly remission, how much? Let's see the rules. Yearly remission would be somewhere around 60 days or something. About 60 days.
Exactly.
Roughly about 60 days.
So
3 years means another 4 or another 6 months a day. Not really. Just find out. The only thing is acquittal, nothing else.
My lord.
Nothing less than that.
Only for acquittal, my lord.
Yes. Read that part of letter. You may get definitely.
I'll try my best to.
You have to create some doubt in so far as PW13 is concerned. Then you are out.
Yes, yes.
Because PW13 is very dangerous.
So also PW14, my lord. PW14
14 is
stated in
hearsay,
evidence
we can
by-
very well
No,
say
no,
hearsay,
no, my lord.
forget it.
PW14 stated in evidence. I received telephone call from my daughter. Thereafter, I sent my son PW13 to his house. He went there and received the letter and handed over the letter and stated that all the accused persons threatened to kill her and also assaulted, demanded her. That is there, my lord.
The phone data that has not
14, my
been
lord.
brought into record. Phone data.
So, ताको तो साइड कर ही जो, किंतु 13 को साइड करें था टिके difficult. You read it out. ये तो अपन टिक देखी कभी कोई भी.
ଟିକେ ଦେଖିଲେ ଆର ୱିକ୍ ଚାଲି ଆସିଲେ ହେଇଯିବ
2 weeks पर रखिए.
ସେଟା ଟିକେ 2 weeks ରଖିଥାନ୍ତୁ
ଜଜମେଣ୍ଟ ଫଜମେଣ୍ଟ କିଛି ଦେଖନ୍ତୁ କାଢନ୍ତୁ.
ସାର୍
ଜଜମେଣ୍ଟ ଫଜମେଣ୍ଟ
ଜଜମେଣ୍ଟ ଟା କାଢିବାକୁ ହଁ
ଯଦି ହେଲ୍ପ କରିବ then
Sir.
we will acquit.
Sir.
In the face of these kind of evidence,
Yes.
you can yes.
177.
Any short matter? Yes, yes.
Oblige,
And
sir.
he has been there. 177, huh?
Yes, sir. May I please, lordship?
Yes.
The appellant is falsely implicated in the PC case.
After you are being convicted by 2 courts, you are falsely saying.
No, lordship, 1 court.
One court. Acha,
Yes,
appeal.
sir, in PC case.
Okay,
yes,
this
sir.
is appeal.
1 court. In that matter,
170?
item 177.
CRLA 157 of
Yes.
14. Vasant Kumar Naik versus State.
Yes, sir. Tell me.
Yes, sir. In that case, your lordship, the seizure document exhibit 6 is not very clearly confined before this Law and Code Bill. Law and Code Bill also question about that fact in running page 19, in para 10 and last para of this judgment. Very clearly confined in the seizure list. The seizure is made from the complainant. That is 4-fold paper which contain the tented money. The tented money contained by the 4-fold paper. That seizure from the complainant. And in the seizure list, there is a signature of the complainant, there is a signature of the IU, there is a signature of the 2 independent witnesses. That fact is not clearly examined. That fact is not clearly only exhibited. So after 4 days of the trap and seizure of this document, complainant is suicide.
And that fourfold paper, about that fourfold paper, how it is removed. Nobody witness can be said, only PW2.
Let us go step
So
by step.
five witnesses.
Let us go step by
I'm coming
step.
to that fact.
One minute. Let us-
Before coming, I only hints that about what that seizure, only personal search of the complainant, that seizure is taken. That material fact is taken.
Sir, let us go step by step.
Okay.
It is an appeal.
Just you know, that
an
finding is not given. So only
Full, I will hear today also, tomorrow also, don't worry.
Okay.
It is appeal. First, let us see demand part.
Yes, sir.
Then
Demand.
acceptance.
Yes, sir.
Then you say why it should
Demand
be-
giving acceptance. Yes,
these, let us go systematically.
Yes. Obviously.
Whether you have demanded or not. Let us see.
That's most fact. First, PW4 statement. 5 witnesses examined.
What are the facts you tell me? Yes.
Fact of the case is
What is the
that-
prosecution story?
The story is that, your lordships, complainant apply on dated 5/1/1997 for apply for the plantation of the 100 acre plantation of the tree over the 100 acres of the land, over the 100 acres of the land, before Tahsil filed an application for the plantation of the 100 acres of land over that area is the Mauja is Rajnagar area.
Yes, it is Rajnagar.
Coming to that.
Where searching plants or what?
No, plantation of the actually it's a date chart result. Actually,
yes.
The plantation of the plantation over the 100 acres of the land. They apply for before the Tahsildar.
I understood it. Proceed.
Then second point is they come to while the Tahsildar directed to the Omina to verify this application is this application according to this application plantation program is used for or not. So RI submit their report to Tahsildar.
Who are you?
I am the appellant. I am the appellant and accused person.
Senior
Who are you?
He is a senior assistant in the office of Director Social.
What is the fact?
Here the accused happens to be the senior assistant or project officer in the office of Director Social Forest Division. Complainant has applied and filed an application. There is a scheme in the forest department for plantation of 100 acres of land. So the modus operandi is this application is to move through the Tahsildar, then it will go to the project Director Social Forest Division, and this appellant happens to be the dealing clerk of that particular application. Okay. To process it, he has demanded bribe and trap has been laid.
Your lordship, after that, on dated 11/3/1997, the Tahsildar sent the report to the DSFO. Sent the report to DSFO. On dated 11/3/1997, the complainant go to the DSFO. In the DSFO, he have to be get some information, some person regarding to that fact, who dealing that case, who dealing that filing. So he have to get information that Basant Kumar Naik, the appellant accused person, is dealing that file. So he have to meet on dated 11/3/1997. Meet kala again, say date. Meet kari ki tanga sahita kahile agya moro that file mo file taku agya apana pass kara. तापर से जिस प्रोसिक्यूशन कहया कथा होची से प्रोसिक्यूशन कंप्लेनेंट कहछि सी मोथर डिमांड कले 10,000 rupees. So I am not unable to give the 10,000. से कहले compromise करना 1,000 rupees. Then on dated 4/4/1997, he go to the vigilance office. Demonstration was made. After demonstration with the trap team, we going to the on 5/4/1997 to the house of the home of the appellant accused person.
Yes.
When you have to going to the appellant with the complainant,
if you are comfortable in Oriya also, you can tell, no problem. Whichever is convenient. Don't get hassle by that. Yes. Yes, no problem.
Yes, sir. I'm comfortable with both.
I'm also comfortable in both. Yes,
During the
the raid was conducted.
when the trap was made,
Right, yes.
trap was made with the complainant, there's a overhearing witness is PW4 with go to the home. At the interesting story about that, nobody can be says about the fourfold paper. Nobody can be says. But in demonstration, very clearly mentioned about the four after you have to be give the tented money with fourfold paper.
What is that fourfold paper?
Fourfold paper, your lordship, is a paper which is containing the tented money.
Okay.
That
it was kept in that folded paper.
That fold paper kept by the complainant, which recovered by the PW5 by way of personal source of the complainant. That is Exhibit 6.
That's a common practice, my lord.
That
When
Exhibit 6.
tainted notes are given, it has to be given in a folder.
That is Exhibit 6.
Your lordship knows.
There is signature of all the. There is a signature of PW5. There is a signature of complainant. There is a signature of the independent witness. For that reason, after 4 days of the trap, he suicide. Not death, your lordship. Suicide. UD case is there.
Because of this case.
Because of that fact is he have to know that he personally know that I am removing it and forcefully give the tented money in his pocket. That fact nobody can be says. Only PW says that we tented.
Why he has committed suicide? Because of this.
Yes, your lordship. As because when personal source is made, he have to very much danger in his mind. That question must be asked, na? When that question is asked.
Therefore, you are presuming that he has committed suicide because he has.
For that material evidence.
He has
for that material evidence.
Concealed some material fact.
Yes, sir.
So under
for
the
that
pressure,
material
under
evidence.
the pressure,
Law and code will also be questioned about that fourfold paper in judgment of the judgment para 10.
That fourfold paper is ignored. Even if it is ignored,
that fourfold
the demand is proved.
The demand is not. There is a doubt about the demand. I'm coming to that point. I'm coming to that. I'm not accepted demand. Because when fourfold paper someone is open.
Fourfold paper comes very late.
Yes, sir. That
is relatable to the trap.
Detection time.
Detection time. But the question of demand
I am not
much earlier to that.
Yes, sir. I am only question about demonstration of what procedure is made. But his intentional is very much different. He very intentionally come. Very intentionally come. Demonstration given, you have to be open the fourfold paper, tented money which is in the fourfold paper. You open it, then this is the when it touch the tented money, you have to be demonstrated very clearly. I am explain about demonstration. In that demonstration, I am very clear. That is clear to all those things. So demonstration is the most important part in the case.
As far as demand acceptance is concerned, PW2 and PW4, they have given the testimony. They have not been cross-examined also. They have never been cross-examined by the defense.
I am admitted. I am not denied that fact. But intention is very behind that. Can demonstration very clearly said that demonstration when I have to read out is very clear. What actually everyone confine about demonstration.
Do you have any judgment to?
Yes, sir. Several judgment.
1 minute. Let me. What judgment you want to?
Judgment is
what was my question?
Question is about the demand.
No. I was asking some question without complete. Also, you jump. Show me any judgment where you can demonstrate that if the intention of the informant is bad, you can't be convicted.
In PC
despite the fact that demand is proved acceptable.
No. Demand. I am coming to the demand. There is a demand also. There is a doubtful.
Why you have not cross-examined the witnesses?
No, I'm not cross-examining.
Then the examination chief has to be
substantial fact is there. Can PW4 and PW2 statement is while corroborated with the PW1 and I mentioned that fact in the written statement that I am read down. There is 2 point is there, so I'll be.
You see, you have to structure your argument. You can't go here, there and all.
No, I say, so
You have to
I'm
structure your
systematic,
argument so that a court can understand.
Yes.
You are arguing an appeal.
Yes, sir. And systematic.
Yeah, unless you structure, how will you?
I'm systematic.
Tomorrow?
Yes, sir.
Tomorrow at 2 o'clock. You structure it,
Okay.
get a written note,
Okay.
and you have a difficult case
Yes.
before you.
Okay.
Don't do it casually, otherwise it is a case of
No, no, I'm
conviction.
very clearly, yes, very clearly.
Okay. Structure your argument. You confine your argument to the demand part,
Okay.
thereafter acceptance part. Then you read out the evidences and try to find out the contradictions or whatever. Then you give those explanations. And then thereafter you get some judgment to support your submissions. Unless you support your submission, you won't get it. It's a case of conviction. A very reasoned judgment.
Yes, sir.
And that's, can it be on next week, madam? Let him also prepare, because tomorrow already 2 matters lordships are already fixed.
Next week, you tell me the one.
It's 11 months.
11.
11.
You have enough time?
Enough time.
Prepare a written note, give it to Mr. Rijvi.
Already let's give him.
Give it to, or if you can develop it, give it
Yes,
to Mr. Rijvi.
yes, sir.
If you relying upon some judgment also, give that judgment to Mr. Rijvi so that he can render assistance.
Okay.
Yes. Any? Yes, sir. Have you found? Okay. Sure. And you tell so that it can be taken up tomorrow. If you tell. Yes. Any small matters? Any small matter where undergone or something of that sort. And see the oldest matter, any oldest matter remains 90s, where the formal order is to be made.
But there's a lot of revision petitions are pending, madam. 149 we have completed the appeals. Only 36 are left in the coming 2 days. In between, my lords, there's
Small matter.
revisions are there. That's
Yes, ma'am. You have some matter? 38.
Twice.
38.
7.
Yes.
4 years. Here, madam, all the witnesses are police witnesses. There is no injury on the part of any of the persons.
Yes, who is appearing? Yes.
Mishra.
For which, madam, 307 is 4 years jail is.
Already.
4 years jail is.
Sentence is 4 years.
4 years.
Undergone how much?
Undergone to 3.5 years खंडे
No, you exactly tell undergone कर छोड़ दे काम खत्म.
काना मुँह आगे ना मुँह को जाके कैकुटल हो.
Forget it. Why should you go into a you need not level and I will level for that. Already undergone, finish, close. You tell me the undergone period. 4 years sentence.
4 years. And fine is
He says already substantially undergone.
Three-
Why unnecessary?
307, 25, 27 Arms Act.
Get it, whatever.
ना कुटल हो.
You have is he government servant?
ना आमो.
Oh, what will you do?
एक criminal है.
Then already undergone. You tell me the undergone period. Undergone period.
जो limitation petition का दे दी सही तो.
The problem is in the bail application, you people don't write during trial period whether you have undergone. And see the bail application. Just see the bail application. now,
Para
5
3, my
facts.
lord. Para 3 of his application, my lord.
Sentence petitioner.
More limitation
Petitioner was arrested and they, my lord, hence he has been inside the custody in these cases for a period of 2 years and 9 months and have served the sentence more than half of the sentence.
Where are you reading?
Well, para 3, my lord.
Para 3 of
It's miscase, my lord, for application for bail.
bail. Para 3.
Para miscase number 5.
That the petitioner was arrested in the aforesaid case for a change. Every detail is written. So and so and was released on bail on so and so. Okay. Again, he was arrested in another case on social day, and after disposal of the appeal, he was remanded in this case on 2000, and hence remanded on 24/9/2010. And thereafter bail was granted by this court by.
He has been inside the custody.
2005 ରୁ 8, 10, 2007 more than 2 years.
2 years ତାପରେ 24/9/2010 ରୁ
ଆଜ୍ଞା
ଏଠି ବେଲ୍ କେବେ ପାଇଲା?
ଏଠି ପାଇଲା ବେଳକୁ ଆଜ୍ଞା 2011 29/6/2011
ତାହେଲେ ତ ହେଇଗଲା ସରିଲା
ତାପରେ ପୁଣି ସେଟା ସେ ବାହାରି ପାରିଲାନି ପୁଣି ଥରେ ଆଜ୍ଞା ମୋଡିଫିକେସନ ଫାଇଲ ହେଲା ତେଣୁ ସେ ବାହାରିଲା ଆଜ୍ଞା 10/1/2012
ହଁ ହେଲା ଅଣ୍ଡରଗୋନ୍ ଚलो ଅଣ୍ଡରଗୋନ୍ ଦେଇଦି अभी कर दो सेंड ऑलरेडी अंडरगोन सेंड फाइन वाइन अछि की
Fine 2000.
फाइन छोड़ो if you insist for fine see how to the crime going to 2000 टका आनी वो दबो आउट केस कर नो फाइन ऑलरेडी अंडरगोन सेंटेंस इज बोर्ड
ना किछि के आगे लोक ना
चिट्ठी देले आसी तो दे दियो पसंद ठीक है ओके
এটা নিজে ক্রিমিনাল I know that.